You move on.
Motion, fresh matters you can give. Fresh matters. Yes. What is fresh matters? Okay. Yes. Adjournments only the other side is here and serial number 30. Number 13. Learned Counsel for petitioner has filed a memo dated 26/7/2023 stating that the prayer made in the petition has become infructuous. Therefore, the petitioner may be permitted to withdraw the writ petition. Full stop. Next para. The memo is taken on record subject to all just exceptions. Stop accordingly. The writ petition stands dismissed as withdrawn.
Serial number 38. I need to file statement.
Other side is here.
I appear for petitioner, my lords. I have no objection.
38.
Krishna sir will ready.
Huh?
Krishna sir will ready. I appear for respond number 2.
Serial number 38. At the request of learned counsel for respond number 2. A week's time is granted for filing statement of objections. Yes.
Great.
One, this matter. Preliminary. Serial number 1. Other on this, take up 9 dimensions, seeking direction from the sound court to consider my application in accordance with law. Due to the garbage, let them, the place of worship, the Daivaradhana and Bhutaradhana, the place of Mangalore has been deteriorated. When it comes with the photographs which I have been placed at page number 25, from page number 25 onwards.
Where is this place?
This is at Mangalore.
No. What is your personal interest in this matter?
No. That in fact, what happened in the ancient case is that we have been residing there from time immemorial. Residing there in time immemorial.
Where?
In the said premises.
In this premises.
How? Namma land has already been acquired by the state government. But place of worshiping, Naga Aradhana and Bhutaradhana, place of Bhutaradhana, that's so for that reason, my lord, the said Dharma Chavadi is still there in the said place. When it turns page number 25 for a moment, page number 25, the photograph which I have been placed, idu Dharma Chavadi. So I am my humble submission before the Sound Court is that, my lord, and preserve the said Dharma Chavadi in the interest of.
You are saying the land is acquired by whom?
Land is acquired by the second respondent, my lord, the Mangalore City Corporation.
For what purpose?
Due to the dampness of waste garbage, my lord. The waste garbage village had to.
It was acquired for what purpose?
Acquired for the said reason only. The entire village has been flooded by waste garbage. So for that reason, land has been acquired. And residents shift made.
Sorry.
The place of worshipping has been.
That cannot be that cannot be something that can be considered in this writ petition. See, at the time of acquisition of the land, if you had not raised such an objection,
no, I have at the time of acquisition, my lord.
It becomes a challenge to the acquisition notification.
Yes.
In the local bodies matter.
But not only myself, my lord, entire villages are worshipping. Entire villages are worshipping. Notice ಮಾಡಿ ಅವರು ಅದನ್ನು ಉಳಿಸ್ಕೊಳ್ತೀರಿ ಧರ್ಮ ಚಾವಡಿ
You should have made that submission raising an objection in the acquisition proceedings. Idu barodilla. Land is acquired, then they'll make use of it.
ನೋಟಿಸ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಹೇಳ್ತಾರೆ.
Learned HCG takes notice for response number 1.
The second respondent, Shri Harish Pandari, Mangalore City Corporation. He is appealing. Matala government. Second respondent, Mangalore City Corporation.
ಏನೋ ನೀವೇನೋ ಇಷ್ಟ ಬಂದಂಗ್ ಮಾಡಿದ್ರಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್.
ಇಲ್ಲ,
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಹೆಲ್ತ್ ಅಂಡ್ ಫ್ಯಾಮಿಲಿ ವೆಲ್ಫೇರ್ ಸೊಸೈಟಿ ಅಂದ್ರೆ
ಫ್ಯಾಮಿಲಿ ವೆಲ್ಫೇರ್ district health family welfare office.
ಹೋಗೋದಿಲ್ಲ, ಅದು ಸರ್ವ್ ಆಗೋದಿಲ್ಲ, ಅದು ಯಾರು ಅಂತಾನು ಗೊತ್ತಿಲ್ಲ.
ನನ್ನ ಆಫೀಸ್ ಅಂತ ಮಾಡಿ.
There cannot be a special land acquisition officer in Mangalore Mahanagara Palike.
ಅಲ್ಲ, entire village has been acquired by himself.
There cannot be such a officer as sixth respondent. ತಪ್ಪು ಮಾಡಿದಿರ. SLA ಒಬ್ಬ ಕಾರ್ಪೊರೇಷನ್ ಎಲ್ರಿ ಬರ್ತಾರೆ.
ಅದು ಗವರ್ನಮೆಂಟ್, ಸ್ಟೇಟ್ ಗವರ್ನಮೆಂಟ್.
ನೋ, ಸ್ಟೇಟ್ ಗವರ್ನಮೆಂಟ್ ಅಲ್ಲಿ ಆಗ್ಬೋದು, ಅಥವಾ KD ಅಲ್ಲಿ ಆಗ್ಬೋದು, ಅಥವಾ ಇದ್ರಲ್ಲಿ ಆಗ್ಬೋದು.
ಇವರು ಸ್ಟೇಟ್ ಗವರ್ನಮೆಂಟ್.
Development authority, like Bangalore Development Authority. If there is any development authority there, Mangalore Urban Development Authority, ಅಲ್ಲಿ ಇರ್ತಾರೆ SLAO, not in the corporation. ಬೇಡ, ತೆಗ್ದ್ಬಿಡಿ. Having noticed the description of some of the respondents is incorrect, learned counsel for the petitioner seeks for a short accommodation to make necessary corrections in the cost type. Full stop. Release this matter on 2nd of July. Full stop. In the meanwhile, office shall permit the learned counsel to make necessary corrections in the cost type. Yes.
Petitioner's claims March 20/2021, annexure B1, lot page 28, entered by the panchayat in respect of the house property. That is lot MR 20/2021. Then lot next page you also kindly see. It is done lot after notice issued to the public, and no after this, let the brother of the petitioner, let after 22 years, he makes a petition before the view of the talak tax without there being an application for condonation of delay. No reasons are given. But kindly see, proceedings are initiated, treated as appeal. When the appeal was posted on 17/3/2023, kindly see page 34. Third date 17/3/23. ಪ್ರಕರಣ ಕರೆಯಲಾಯಿತು. ಮೇಲ್ಮನವಿದಾರರು ಮತ್ತು ಎದುರುದಾರರ ಪರ ವಕೀಲರು ಹಾಜರಿರುತ್ತಾರೆ. ಎದುರುದಾರ 1, ದಟ್ ಈಸ್ ದಿ ಪಿಟಿಷನರ್, ಪರ ವಕೀಲರು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಲು ಕಾಲಾವಕಾಶ ಕೋರಿತು ವಿಚಾರಣೆಯನ್ನು 13/4/23ಕ್ಕೆ ಮುಂದೂಡಲಾಯಿತು. ಆನ್ 13/4 ಪ್ರಕರಣವು ಚುನಾವಣಾ ನೀತಿ ಸಂಹಿತೆ ಜಾರಿಯಲ್ಲಿರುವುದರಿಂದ ಮತ್ತು ಪೀಠಾಧಿಕಾರಿಗಳು ಚುನಾವಣಾ ಕಾರ್ಯದಲ್ಲಿ ನಿರತರಾಗಿರುವುದರಿಂದ 2/6 ಮುಂದಕ್ಕೆ ಮುಂದೂಡಲಾಗಿದೆ. Thereafter, next page, without notice, he preponed it on 20/5/2023. Order has been passed.
ದಿನಾಂಕ 20/5/2023
ಹೌದು,
ಉಭಯ
ಒಪ್ಪಿದಂತೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಮಾಡಿ. Without notice, Lord, when the matter is adjourned to 2/6/2023, there is no application, my lord, filed for preponing the case. I have no notice. Order has been passed, my lord, without giving an opportunity. Earlier date, my lord, the lordship has seen. I engaged an advocate, my lord, we requested to time to file objection. It was granted. On 13/4/2023, when it's posted, in view of the election declared, and it was posted to 2/6. But, my name is there from last 22 years. Even by petition, my lord.
Which is the order?
Annexure A is the order. Page 14. Compromise ಆಗಿದ್ದಾರೆ ಬಂದು ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿ ನಮಗೆ ನೋಟಿಸ್ ಇಲ್ಲ.
Learned HCDP takes notice for respondent number 1. Issue emergent notice. Devrajra? Huh? Learned Counsel Shri DJ Somyaji is requested to take notice for response number 2 and 3. Issue emergent notice to respond number 4. Stop. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the petition along with the annexures on Learned Counsel for response number 2 and 3 and a copy on the Learned HCG. We'll stop. Next para. Learned Senior Counsel Shri A.G. Shivanna appearing for the petitioner draw the attention of this court to the order sheet maintained by the second respondent executive officer of the Taluk Panchayat, Malu. So, Learned Senior Counsel submits that the appeal filed at the hands of the fourth respondent before the executive officer was adjourned on 17/3/2023, granting time to the petitioner to file statement of objections, and the matter was directed to be called on 13/4/2023. So on 13/4/2023, the matter was adjourned to 2/6/2023. So, however, on 25/2023, it appears that the earlier order was recalled and it is recorded that the parties have settled the matter and the impugned order dated 25/2023 at annexure A is passed by the executive officer directing the respondent Gram Panchayat to enter the name of the fourth respondent in the Qatar register in respect of a portion of the property. We'll stop. Learned Senior Counsel submits that the petitioner never entered into any compromise or settlement with the fourth respondent, and the statement recorded in the order sheet is incorrect. We'll stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order at annexure A, comma, till the next date of hearing.
Number 3, Mama Tayyar, member of the petitioner. Similar order may be passed to the bylaws of the society.
Same orders. Same orders as in WP number 13460 of 2023, dated 30th of June.
Here number 5, 6, 25 and 27 are similar.
5, 6.
25 and 27. To legible copy of the bylaw and raise an objection, I comply with the same.
25,
And 27.
27. 25 ಮತ್ತು 27 ಅಲ್ಲಿ in the meanwhile office objection shall be complied with ಅಂತ ಸೇರಿಸ್ಕೊಂಡು.
Page 29, annexure D may kindly be seen.
Twenty
29. Honorable Minister directs start the inquiry. Against this, I filed a writ petition. An interim order of stay of this direction was granted. But even before that could be communicated, annexure E is issued, page 34. Starting an inquiry under section 64. ಅದರಲ್ಲಿ ಉಲ್ಲೇಖ 3 ಮಾನ್ಯ ಸಹಕಾರ ಸಚಿವರ ಟಿಪ್ಪಣಿ ಸಂಖ್ಯೆ ಸೊ annexure E. Again, annexure E, I challenged annexure E. And this honorable court was pleased to grant an interim order of stay at annexure L, page 56. The condition is important that if any allotment is made hereafter, they should mention about the pendency of these cases, etc. It is being complied. Now, under annexure Q, page 68. To circumvent this interim order granted by this court. Now, an order is passed at annexure Q saying that we are holding an inspection under section 65. They kept left that section 64 inquiry. Now, an order is passed to initiate inspection under section 65 on the same allegations. Your lordships get the allegations at page 69 bottom. ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯನ್ನು ನಿರ್ಮಾಡಿಕೊಂಡಿಲ್ಲ, ಪ್ರೆಸಿಡೆಂಟ್ ಅವರ ಸಂಬಂಧಿಕರಿಗೆ ಸೈಟ್ ಅಲಾಟ್ ಮಾಡಿದಿರಿ, which are the very same allegations under the earlier order also. To circumvent the interim order granted here, they have now quoted it as section 65. They issue legal. One single
Who has issued legal notice?
they can issue legal.
Hmm.
Both of you have already scored. The moment you should trade property to the middle public in order to cheat the client society and make money of the gate, even though you receive an amount from the credit public. All these amounts are received by the members. These are the members. And the earlier paid they are also given. What are those savings? Correct. Page number 193, 291, and not the only. Then, correct. Page number
That is a legal notice issued to some.
Society contract.
What has that got to do with this?
Contract has, they issue contract has shown those things. Unlimited one. These sites are allocated to us, para number 2, para number the legal. Agar both of you execute registration for.
Both of you have not executed.
Not execute. All these sites you have executed registration. But even today, both of you are not coming forward to execute the registration. My client society member, even though both of you have received consideration for the matter of pension. We have to make the freedom.
Who, sir? You are making submission on whose behalf?
All these members, my impeding application is allowed.
Impleading applicant, sir. Matter inu barta ide. Where are you? We will see. We will see. Yes. Not at this stage, sir. You cannot be heard in this stage. You file your application. We'll see.
Last week
No, sir.
Sections.
Sir, their grievance is against inspections ought to be made by the officials. What has that got to do with you?
Whatever process.
Sir, if you want to file an application, you file. You will have no audience at this stage.
At least earlier.
You will not have an audience at this stage in this matter. You file your application, we'll consider. Yes, madam. Yes. Allah, Nimma, the proceedings that you initiated under section 64 has been stayed by this court. Why are you doing all this? Again, you are trying to initiate a proceedings under 65. Any allotment will be subject to.
That order and the petitioner was given communication to you next page. ಎಲ್ಲರ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಕಾರಣಕ್ಕೆ ಅಧಿಕಾರ ಪರೀಕ್ಷೆ ಸದರಿ ನೋಟಿಸ್ ಅಂಶಗಳ ಅಂಶವಾದ ಸಲ್ಲಿಸುವುದು ದಾಖಲೆಗಳು ಉಲ್ಲೇಖ ಹೊಂದಲು ನೋಟಿಸ್ ಸಂಖ್ಯೆಗಳ ಅದನ್ನು 4 ಸಮಸ್ಯೆಗಳು ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಹ ಸಮಂಜಸ ದಾಖಲೆಗಳನ್ನು
ಅಲ್ಲಮ್ಮ What is the use of reading all that? You initiated proceedings under section 64 on the same cause of action. That proceedings have been stayed by this court. Where was the occasion for you to initiate proceedings under 65 once again on the same cause of action? But Audama, you initiated proceedings under section 64 that has been stayed. Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. Learned senior counsel Sri Jaykumar S. Patil, appearing for the petitioner society, submits that on 2 occasions this court has stayed the proceedings initiated under section 64 of the Karnataka Cooperative Societies Act.
Both the petitions are pending.
And both the writ petitions are still pending consideration before this court. Stop. When that is the position, comma, the impugned order has been issued, passed by the Assistant Registrar of Cooperative Societies.
Additional. Upper additional register.
The third respondent, Additional Registrar of Cooperative Societies, directing initiation of proceedings under section 65, but on the same cause of action. Full stop. Learned senior counsel submits that this would amount to this action on the part of the Additional Registrar of Cooperative Societies would border on contempt, since the initiation of proceedings under section 64 has been stayed by this court, and there was no occasion for the Additional Registrar to initiate proceedings under section 65 on the same cause of action. We'll stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 13/6/2023 at annexure Q, till the next date of hearing. Yes. ಮಾಡಿದ್ದಾರೆ sir ಅದರಲ್ಲಿ whatever you could have gone and made your submissions before in the pending matters. Who has to mention? If there is any difficulty for you, you should have made an application there. Yes. Allotment allama, your contractor, your. All right. Yes. Aki. Yesterday, in one matter, similar situation, learned senior counsel Mr. Ravi Shankar had argued, basing his submissions on a full bench decision of the Patna High Court. Please listen. His submission is that the proceedings initiated under section 64, 65, 68 is under a different chapter when compared to proceedings under section 70. These proceedings are administrative in nature, whereas a proceedings initiated under section 70 is a quasi-judicial proceedings, where adjudicatory proceedings, So if at all a member is aggrieved, he has to initiate a proceedings under section 70. He cannot depend for redressal of his grievance in an inquiry conducted under section 64 or 65. This is only bringing to your notice. So therefore, if you are aggrieved, you had to initiate a proceedings under section 70. Please do it.
I was allotted site with the order.
Sir, ನಿಮ್ದು ಏನೇ dispute ಇದ್ರುನು it has to be raised under section 70.
Section 64 inquiry is regarding management of the society.
ಅದು it's administrative in nature. Please understand. If the member of the society is aggrieved of non-allotment of site or non-conformity with the seniority list, all that, he has to raise a dispute under section 70. You cannot rely upon an inquiry initiated under section 64 or 65. It may not help you.
What I say, if inquiry which all our complaint were necessary for the code on the.
Paradilla, sir, you may not get relief in that one. Please understand. Yeah, it is up to you. Yes.
I have difference of opinion in this matter.
I to mark issue. See, you do whatever you want. Ultimately, I'm only trying to tell you there is a decision of the full bench of the Patna High Court which has made such a distinction. So interim orders or no such orders can be passed in a inquiry proceedings under section 64 or 65. It may not help you. It's up to you. Sorry.
Number two, earlier there is a direction mentioned pending on the petition. There are 4 banks they have sold. But you are thinking in single they mentioned.
All right. Yes. Next matter.
Number 7, 10.30 A.M. Number 7.
Petitioners had got ballot for the purpose of construction. Now we had applied for the Qatar to be issued to us. Now the respondent number 2 has not issued us the Qatar that we have asked. Further, we have also requested the respondent number 2 to collect taxes from us. They have denied to do. Have filed submitted representations regarding the same. All we want is a direction. I think the respondent number 2 consider our representation, my lord, for the issuance of Qatar.
Where is your application?
Now it's annexure B1 to B7. We have filed a representation, my lord.
No. Kata, there is a separate application form, and I think it is now to be made online. This kind of representation cannot be considered. We will grant you permission to file necessary application in accordance with law. Let them consider. Oh, Gram Panchayat. Learned AGA takes notice for respondent number 1. Learned Counsel Shri MS Devaraj, who is present in the court, takes notice for respondent number 2. Full stop. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on the Learned Counsel for respondent number 2. Full stop. Next para. Release this matter on 2nd of August 2023. Full stop. Learned Counsel for respondent number 2 shall take instructions from the second respondent regarding the representations given by the petitioner to register the Khata in the name of the petitioner on the strength of registered instruments.
Made representation to that day. Cleaning of the usual. They made a representation at the impugned level. The same needs to be considered by the BBM.
Learned Counsel Sri Pawan Kumar, who is present in the court, takes notice for all the respondents. Learned Counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on Learned Counsel for the respondent.
Lord, I appear for petitioner. Lord, the petitioner,
Yes,
Lord, he purchased a site, my Lord. Lord, in former Kallahalli village, my Lord, in Shumaga Taluk. Lord, annexure A is the sale deed. Lord, it is dated, Lord, 21/10/1966, my Lord, page 33, typed copy, page 33. It was, my Lord, earlier coming within the jurisdiction of a panchayat, 33. 32 is the sale deed. 33 is the typed copy. My Lord, he purchased, my Lord, the owner of a survey number. My Lord, he formed a revenue sites and he sold the sites to various persons, and petitioner is one among them. My Lord, after purchase, your lordship finds it 34 is the layout plan prepared by the owner, page 34, annexure B. My Lord, he was in the year 1972, he put up a construction and he is residing along with his family. My Lord, because it was an agricultural land, annexure C, my Lord, Kata was mutated in his name based on the.
but there is no interim prayer.
No interim prayer.
What is it that?
No, my Lord, they are not issuing Kata after it was, my Lord, included in the, my Lord, jurisdiction of the municipality. They are not issuing.
Area takes notice for respondent number 1. Yara perakತಾರೆ city corporation ಗೆ?
My Lord, Ashwini Haladi. Learned
Counsel Shri Ashwin Haladi is requested to take notice for respondent number 2. Learned Counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on Learned Counsel for respondent number 2.
Obliged.
Similar to in this matter, this is the effective skywalks on the advertisement tag.
What is it?
Fresh demand notices are being issued on it, despite there being an agreement on which the concession fee is given. On the next page, the entry model is rejected. Similarly placed on the same ground, similar ground. Agreement with the BBM, skywalks have been put up. As per the agreement, there is a concession fee on ground rate which I need to bear.
What is the order, sir?
The third paragraph, Shri Pawan Kumar, Learned Counsel, was directed to get instructions with regard to ground rate and what is the basis for indicating so and so the ground rate. Based on till then, the parties to maintain status quo with regard to the following.
Ground rent.
Please, there is a concession agreement with respect to each of the skywalks. In 2022, they issued the first time demand notice. So others now reply what they that they cannot impose additional advertisement tax and tax tax. They are imposing GST over advertisement tax. They consider my reply. Don't do anything there. Now after 1 year, they again issue another fresh demand notice. Last year, they demand notice same to same capture money. They will put agreed by them. This petition also had approached the Dishonorable to grant the interim order. I am also on the
Here interim order. I don't find any interim order here.
The status quo has been granted. List on 22/2023 till then the parties to maintain status quo with regard to the following. Annexure A demand notice bearing so and so. Annexure B demand notice bearing so and so. Then the parties to maintain status quo with regard to the following. Annexure A demand notice bearing so and so dated 15/12/2022. If 15/12/2022 demand notice were also issued to us, now the same demand notice has again been issued to us. Annexure A to J are the include demand notices in this petition.
But you had not approached this court earlier?
On the earlier round, I had not approached because I had given a reply. That they cannot impose such. Our other they did not take any steps. I may, if I may permit it, on the same demand notice, I just juxtapose and show that our last year in demand notice same demand notice. And one more point is last year amount. Will kindly see the first demand notice last year 44,78,793 annexure L only claim ಮಾಡ್ತಾರೆ. ಈ ವರ್ಷ ಅವರು 6/7/2023 ಕೊಡ್ತಾರೆ 43,37,193. Idರಲ್ಲಿ because my ground rent is 70,000 plus GST 84,000. I have already paid it to them. They have accepted my payment also. But same demand on the same point, ಈಗ ತಿರ್ಗಾ issue ಮಾಡ್ತಾ ಇದ್ದಾರೆ because kindly see annexure A for a minute. I'll just kindly demonstrate this. Annexure A is the issue demand notice now with us 6/7/2023.
ಇದೇನು ಕಿತ್ಕೊಂಡೆ ಬಂದ್ಬಿಟ್ಟಿದ್ಯಲ್ರಿ ಇದು annexure A.
I will stitch it.
Yes.
And let me kindly see annexure L at page 69. The two demand last year or the year.
Page number
69. Annexure L. If I 2022 to end demand notice last year, it Namtara very advertising agency the same demand notice.
69
annexure L. Let me kindly see the table. Our literally Nanak heads and in totally 5 heads they are making the claims on which they are demanding this advertisement tax.
Yes.
They are dividing Vasa bylaw prakara they divide the two tenures 1/7/2017 in the 13/1/2020 was amene 14/1/2020 in the they are again demanding the new amount. They are trying to impose advertisement tax on the two differential dates as per this bylaw. But once the GST regime has come in, and if we are repaying GST under this under the constitutional amendment, the imposition of this advertisement tax is altogether been taken away. Parent enactment unless there is no authority to impose the advertisement tax. I am paying GST altogether. Our GST the central government go over the state government go over there. According to that, the state is earning its revenue. Now, despite that being there, their additional advertisement tax has been sought to be imposed.
No, but you have paid this.
I have paid my ground rent with GST. That is an annexure.
The demand raised at annexure L.
Please, I have not paid this. I have paid under the agreement. My agreement is at page number. Kindly see, agreement starts at page 135. 137 is the clause with us.
No, but you did not question this demand notice.
I have given the reply to them that I am not liable to pay. My reply is at the very next annexure L1. They don't, after the demand notice, when I give my reply.
Do the same thing now also then.
Because I have already given my reply because they are threatening that they will remove the voting.
If they have not done it last year and they were satisfied only with your reply, what is the difficulty?
I have given the reply on annexure L. Annexure Y1, Y2, Y8, I have given the reply telling that last year Pura and the reply ಕೊಟ್ಟಿದ್ದೀವಿ. ಈಗ ನಾವು same demand notice ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ ನಾನು reply ಕೊಟ್ಟಿದ್ದೀನಿ because annexure Y2, Y8 out within 7 days give the payment ಅಂತ ಹೇಳಿ ಇದು ಮಾಡಿದ್ವಿ because within the 7th day I have filed this thing. ಈಗ they are threatening that they may remove the voting altogether. Annexure Y page 208. Similarly, another advertiser has already approached this.
Learned AGA takes notice for respondent Burban. Learned counsel Shri Pawan Kumar, who is present in the court, takes notice for all the other respondents. Learned counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on the learned counsel for the respondent BBMP and a copy on the learned AG. We'll stop next para. Learned counsel for the petitioner submits that under similar circumstances in WP number 1966 of 2023, comma, this court, comma, by order dated 10/2/2023, I directed the learned counsel for the respondent BBMP to secure instructions with regard to the ground rent and what is the basis for indicating rupees 16 lakhs each year as ground rent under the demand notice. Full stop. Further, parties were directed to maintain status quo with regard to the impugned demand notices in the said writ petition. Full stop. Learned counsel prays for similar relief. Full stop. Next para. Consequently, there shall be an interim direction to the parties to maintain status quo with regard to the impugned demand notice.
Section A to J.
Impugned demand notices at annexure A to J, comma, till the next date of hearing.
ನಾನು ಸ್ವಿಚ್ ಮಾಡ್ತೇನೆ ಅಷ್ಟೇ.
Mostly ಇಲ್ಲಿ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಅವರು. They may not be able to do it here.
Even the switch ಮಾಡ್ತೀನಿ. I'll make it.
Please do it there in the office. Yes.
Petitioner seeking only voting rights.
Huh?
Only voting rights. For one annexure C ನಲ್ಲಿ serial number 111 111ನೇ serial number ಇದೆ. Harish Kullal. Thank you. See annexure. See page number 20.
Learned AGA takes notice for response for 1, 3 and 4. Learned counsel Sri TL Kiran Kumar is requested to take notice for respond number 2. Issue emergent notice to respond number 5. Learned counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on learned counsel for respond number 2 and a copy on the learned AGA. We stop. Same orders only for
Voting rights.
ಯಾವತ್ತಿರೋದು
5
ಇನ್ನೂ ಟೈಮ್ ಇದೆಯಲ್ಲ ಬೇಕಾದಷ್ಟು.
These petitions not inside and consulted the house from one Sirama and Ramakrishna. Page number 21. Annexure C. Earlier, my lord, when Shivappa raised a dispute that my lord, the Ramtana body is not left, some Sirama and Ramakrishna acquired those Ramtana road. My lord. For that, my lord, Sirama left the 20 feet instead of 8 feet road. 20 feet road has left to the Ramtana road, and the Tahsildar passed an order. And as per the order, 20 feet road is in existence now. And against that order, Sirama filed appeal. Appeal also dismissed. Thereafter, my lord, they left the 20 feet road for using the village adjustment. Without disclosing this fact, it's the fourth respondent father also party in the proceedings. He filed a writ petition before this Honorable High Court. Kindly see page number 80. Consider representation, my lord. This Honorable High Court, my lord, in this writ petition, I am not made as a party. These petitions are not made as a party. This Honorable High Court, my lord, directed the respondent consider the remove the impugnment accordance with law. Because this Honorable High Court also has not disclosed, without giving any notice, without any consider proceedings. Can you see annexure A, page 80, saying that, my lord, 3 days notice they given, and saying that, my lord, I have to this petition has to remove all structures. And now, my lord, daily, my lord, they are, the JCB, they want to remove the structure. Instead of that,
You have not given any reply?
I give for this one, my lord, I gave a reply. Can you see page number, all petitioner gave a reply on page number 83. It shows that, my lord, the earlier proceedings, is a 20-foot road, is left for the purpose of villages. It was a Sirama, it's a
Learned AGA takes notice for respondent number 1. Learned Counsel Shri BJ Somyaji is requested to take notice for respondents number 2 and 3. Issue notice to respondent number 4. Learned Counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on Learned Counsel for response number 2 and 3 and a copy on the Learned AGA. Full stop. Next para. Learned Counsel for the petitioner submits that in the impugned notice dated 14/7/2023, issued by the third respondent, Panchayat Development Officer of Nidige Gram Panchayat, the petitioners are directed to remove the so-called encroachments within a period of 3 days from the date of receipt of the notice. Full stop. Learned Counsel submits that although a reply has been caused by the petitioners as found at annexure N series, nevertheless, the Panchayat Development Officer is seeking to take action without affording opportunity of hearing. Full stop. It is the contention of the petitioners that they have not encroached upon any public street. Full stop. Next para. Consequently, there should be an interim order of stay of the impugned notice dated 14/7/2023 at annexure A and all further proceedings thereto come out till the next date of hearing.
Kindly see, half title I wanted to explain. This may kindly be. Page 6 minutes. Let's find number 4, 5, and 6. All the three may not housing credit cooperative society. Not DEL employee. Respondent number 4 is not society having area of operation in Bangalore, urban, rural, in Ramnagara district. Respondent number 5 is Mysore, having area of Mysore town corporation and one holding in Mysore colony. Then the 6th respondent is not AGM. It is having area of operation at Kolara. All these three societies separately registered, having separate registration certificate. The problem what we have is that they kindly see when the tabular file not extracted, they kindly go to page 15. It is only a sample. There are 20 cases to extract.
Page number?
Page number 15, 15, in my petition. There is a 20 members of the society. There are members of the society at Mysore as well as Bengaluru also. You are given the numbers of Bangalore, the voters numbers, as well as Mysore also. Even in this case applicable to KDF is also like that. Ultimately, our complaint we have addressed before the authority. If a similar cooperative societies are there, person is prohibited from gaining the clear membership of another society having carrying the similar nature of the business. It is prohibited under section 17.
But I think it is restricted to the district.
No. Even restricted to the district also.
Anyway, you want them to take action.
Oh, yes. Now, one submission I would like to place it.
Let us see what interim order, no interim order can be granted.
Interim order, why I am placing at this table.
In what kind of
There are
interim?
1,600 this kind of manipulations are there in total.
Sir, unless the competent authority consider that and disqualifies them, what kind of an interim order can be given?
Section 17 may kind of.
What kind of an interim order can be given now?
Section 17 may kind of.
Yes.
Of the act.
Yes.
Section 17 may kind of. No adjudication is contemplated under section 17. That's what I wanted to enlighten.
Yes.
That no person shall be eligible for admission as a member of a cooperative society. A, B, C may not applicable. D is already a member of a cooperative society, carrying on same business of the same kind as itself. That is class D. Then your lordship may kindly go to subsection 2. If a member becomes a subject to any of the disqualifications specified in subsection 1, he shall be deemed to have been ceased to be the member from the date when the disqualification was incurred. May kindly go to 2A. If any person is found to be a member, continuing as a member in 2 or more cooperative society, carrying similar business, it shall be obligatory on his part to retain the membership of any one cooperative society, choice within a period of 90 days from the date of commencement of Karnataka Cooperative Society funds. If he fails to do so, his membership shall be deemed to have been seized in the cooperative society in which he is newly admitted. If any question arises as to whether a member is deemed to have ceased or ceased to be a member under subsection 2 or 2A, the registrar may either so moto or a report made to him after giving an offer to person concerned be heard and decide the question.
That is what I am saying. Unless
No, what
an order of disqualification is passed.
What needs to be decided, it is not whether it's a member or not, it is to be.
Sir, all right, sir, but there has to be an order of disqualification.
By submission.
Without there being an order of disqualification, what kind of an interim order can be passed now?
But what I sought for, election process if commenced on the basis of.
Agadilla. You have to move the registrar and get an order of disqualification.
We have already moved.
Madly out.
Sir, initially.
Let it pass orders.
I think so, it may not several. There's a correspondence interest between.
Please ensure that an order is passed.
ಅಲ್ಲಿ
ಮುಗ್ದೋಗುತ್ತೆ.
152.
AGA. Anyway, we are not considering anything, not even an interim order now.
My submission is.
Allah, not necessary. See, if it is a simple direction to the authority to consider the disputes that you have raised and close it within a time frame, that direction can be given.
That direction only we sought for. I'm not on any other things. In addition to that, suppose that keeping that issue pending before the registrar, if the election process is commenced, it becomes infectious. This is happening not only first time, since 2 decades going on like that. I produced several documents to show interstate between election commission, registrar and the cooperative society. More than half a dozen correspondences are there. Deliberations are there. Registrar has said it is election commission has to do it. Election commission said it is the registrar has to do it. When our society is asked to furnish the detail, Even the details are not been provided.
Clear ಆಗಿದೆಯಲ್ಲ, it is the registrar in terms of subsection 3.
What is to be decided by the registrar? There is already a deemed disqualification. Whether that disqualification is there or not, only to be identified, not beyond that. Question of what to be hurry, whether he is a member. Suppose me not respondent number 4, 5 and 6 are there. If I am member of respondent number 4 Bengaluru society, if I have become the member of 5 and 6, I have to apply for ceasing of my member within the later societies according to my term. Either I can retain membership with R5 or R6 or 7. There's time stipulation is there within 90 days. If it is not chosen by me, then deemed provision would apply. According to the deemed provision, it ceases with other two cooperative societies. It is retained with the primary membership with the society where I have got enrolled. That was the arrangement made in the law. It's only to be identified by the registrar.
But subsection 3 makes it very clear.
Yes.
That if there is any question, it has to be decided by the registrar.
That what question to be decided is also explained by subsection 3.
Yes, yes. If any question arises,
Question arises as to whether a member is deemed to have ceased or has ceased to be a member under subsection 2 or 2A, the registrar may either so much. The Caesar, he deemed to be the member, is already there. That only identified, that's all. No adjudication is contemplated because of the deemed. But this issue is covered by the division bench judgment, not the kind for a union. Okay, division bench explain at the
yes,
This is 2005 ILR 5673.
yes,
May kindly go to paragraph 5. Section 17 is extracted. Then may kindly go to paragraph 6. A reading of the aforesaid provision would indicate that a person is ineligible for admission as a member of a cooperative society if he has incurred any disqualification as envisaged in clause A to D of subsection 1 of section 17. Here, for our purposes, clause 3 is applicable. It says that if a person is already a member of a society carrying on business of the same kind, then the person is ineligible for admission as a member of a cooperative society. Subsection 2 of section 17 of the state, it states that if a member is subject to the disqualification specified here to be subsection 1 of 17, he shall be deemed to have ceased to be a member from the date when his disqualification has incurred. The legislature knowingly has used the expression deemed to deem that a person who has acquired the disqualification which are contemplated under clause A to B of subsection 117 is ineligible to be a member of other society. This is all section 17 of the Act. This is the scheme of the Act. They said, your lordship, similar provisions, other legislation, there an adjudication is contemplated. It is specially framed by the state legislation. Section 7, disqualification is already there. What is required by the deed, on what date he incurred, and which society he wanted to retain. That precisely the point. It is nothing is required to be adjudicated. In that context, we sought for an intelligibility. We rendered all efforts with the authorities to revise our voter list. Now, when our voter list, draft voter list is published, election will be due in the month of September 2023. Now, if the election process commences, this question we could not be able to address. Every occasion, what happens is these people carry the people from Mysore and also from the KTF. They will permitted to cast their vote. And this game is going on only for the purpose of play of dance of democracy. That at least now this could be avoided by what it's a 17 minority.
sir. This kind of relief cannot be given.
My submission is direct the authority to adjudicate. Till adjudication can be stipulated within 1 month or 30 days or 50 days, whatever it may be. By that time, the process of election would not be declared. Rendering our efforts.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್.
register and ARCS having jurisdiction to adjudicate. That is the reason. State register is also a registrar under section 2 of the society's definition.
If that power has been delegated to the assistant registrar, there is no difficulty.
Now, adjudicating authorities of this kind of society is the ARCS. ARCS is made a party. ARCS is made a complaint. He is at the election commission. When section 13 capital A says, election commission is the wholesale concern so far as all election issues are concerned. So, lordship may kindly see section 39 A.
No, it's all right. Now, if you
Selection of the members of the board, office bearers of a cooperative society, including fact casual vacancy, shall be held under the superintendence of the cooperative election authority. Now, voter list issue is a part of an election process. It is not independent of that. Assistant registrar will not be a complaint. Assistant registrar called upon the information from all the society. They did not furnish. Reminder was issued. Now, another reminder was issued by the assistant registrar, warning them it would give list to initiate 29C proceedings. Thereafter, matter was intersect correspondence with election commission and the assistant registrar. Now, the election commission says it is an administrative function you do it. Assistant registrar depends upon the society. Society does not want to publish the information. This dilemma is going on. Ultimately, 1,600 members are now become the members of all the three societies. Having direct bearing on the issue of elections. Therefore, we are before your lordship. Our prayer is also very limited. May kindly see what the relief is sought for. We sought for a mandate. Directing respondent number 2 to consider the representation dated 12/7/2023 submitted by the petitioner, exercise the suo motu power jurisdiction to disqualify the dual membership on the rules of respondent number 4. Issue writ of mandate directing all three not to hold election to respondent number 4 till respondent number 2 complete the suo motu exercise of initiated under section 17 of the Act. This is the relief I sought for. Because September is the due. Very recently we have made a complaint. These complaints have been made since more than 1 year. In addition to that, an inquiry was conducted under section 64. It is reflecting the inquiry report also. I have produced the inquiry report, may kindly be seen below. It is not a new issue or because of an election we are not addressing that. Your lordship may kindly go to page 129 election evening. Here also, that your lordship may kindly go to page 130, Sadashatva Parishilane heading.
130?
131, Dora Muhatma. It's a report under section 64. ಹಾಲಿ ಸಂಘದಲ್ಲಿ 31/12/9 9,222 ಜನ ಸದಸ್ಯರು 2,057 ಸದಸ್ಯರು ಸಹಕರಿಸಿದ್ದು 7/9/70 ನೋಂದಣಿಯಾಗಿದ್ದು ಸಂಘದ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯು ಭಾರತ ಯೂನಿವರ್ಸಿಟಿ ಸೀಮಿತವಾಗಿರುತ್ತದೆ. ಸಂಘದ ಬೈಲಾಗಳ ಸಹಕಾರ ಸಂಬಂಧಿತ ನಿಬಂಧಕರು ಪ್ರಾಂತ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಪ್ರಕಾರ ತಿದ್ದುಪಡಿಯಾಗಿದ್ದು ಕಾರ್ಯವ್ಯಾಪ್ತಿ ಬೆಂಗಳೂರು ಜಿಲ್ಲೆ ಕೆಜಿಎಫ್ PM ಕಾರ್ಖಾನೆ ಸದಸ್ಯತ್ವ ನೀಡಿರುವುದು ಕಾರ್ಯವ್ಯಾಪ್ತಿ ಹೊರಗಿನವರಿಗೆ ಸಹ ಸದಸ್ಯತ್ವ ನೀಡಿ ನಿವೇಶನ ಕಂಡು ಬಂದಿರುತ್ತದೆ. This is the membership is given to the members who are outside the territorial limits of the concerned society of area of operation. Followed by section 68 order is issued at page 133 election of. This is still it is going on, my lord, since 2013.
It's surprising why you are not able to get an order of disqualification.
That's my lord, whole problem is that now the assistant registrar asked the commission to do it. Commission said, it is your duty, you do it.
Yeah,
Assistant registrar has
subsection 3 is very clear. It is the registrar only was to do it.
Anyone has to do it. I cannot catch hold of the next to do the.
Berkeley.
These are all the things I have done honestly to emphasize your lordship.
Learned age.
Matter we are pressing.
takes notice for response number 1 and 2. Learned Counsel Sri T.L. Kiran Kumar is requested to take notice for response number 3. Issue emergent notice to response number 4 to 6. Stop. The petitioner is also permitted to take out hand summons to response number 4 to 6. Full stop. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on Learned Counsel for respondent 3 and a copy on the Learned AGA. Full stop. Next para. Learned Senior Counsel Sri M.R. Rajgopal, appearing for the petitioner, submits that although a finding is given in an inquiry report conducted under section 64 in respect of the 3 societies which has got common members and although representations are given by the petitioner and several other persons, several other members of the society seeking orders of the Additional Registrar of Cooperative Societies to invoke the suo motu powers conferred under subsection 2 of section 17 of the Karnataka Cooperative Societies Act, 1959 and disqualify the members who have dual membership, no orders are passed till date. Stop. It is submitted that the Additional Registrar of Cooperative Societies and the Cooperative Election Authority are trying to pass on the buck between each other without taking the responsibility of declaring the members holding dual membership as disqualified from one of the societies. Stop. Next para. The second respondent, Additional Registrar of Cooperative Societies, is hereby directed to give instructions to the Learned AGA as to why no action has been taken by the Additional Registrar in terms of subsection 3 of section 17, which confers suo motu powers on the registrar to decide the question as to whether a member is deemed to have been disqualified for the reason that he or she is holding dual membership, contrary to the provisions contained in section 17. Contrary to clause D of subsection 1 of section 17 of the Act. Stop. Next, release this matter on 2nd of August 2023. Full stop. Please take instructions and he has to say within what time he is going to pass the orders.
Second, may not to persist place for a election is
Parallel.
till second.
Marak parallel.
Kalyana.
Pass over. Yeah, Ridha. Pass over.
Vision.
Related to become license agreement, seeking appointment of arbitrator. Right of giving notice, respondent not turned up to give consent for appointment of.
Leave and license agreement.
Yes, ma'am. As per class 15 of the at the in page number 41. Class. Agree that in case of any dispute arising in respect.
Yes.
Of settlement. Lord, as per this leave and license agreement, the respondent is agreed to pay rents. The premises occupied by them. But almost 1 crore dues are there. Rents. Now, I've also filed arbitration application before the district court.
Where is your demand notice?
Demand notice at various demands by their mail.
Annexure H.
Annexure G, H. G also, G series also demand rises by through email and annexure H.
Yes.
Also recently given annexure M. They have not appeared before arbitration application which are filed before district court for interim protection in A number 9.
Perfect. First paragraph same. Second paragraph. Learned counsel for the petitioner submits that the parties herein entered into a leave and license agreement dated 13th of November 2021 at annexure F, whereby the petitioner, who is the owner of the premises, granted the premises on leave and license to the respondent, and the respondent agreed to pay license fee every month for the usage of the premises. Stop. Nevertheless, on default on the part of the respondent, demand notices were issued by the petitioner. Stop. Attention of this court is drawn to annexures
H and
G,
H and K.
G,
G, H and K.
H and K. Stop. K Allari. K is a arbitration notice.
Arbitration, yes.
G and H.
G and H.
Stop. Thereafter, comma, the petitioner invoked the arbitration clause contained in clause 15 of the agreement and issued notice on 3/2/2023 at annexure K, nominating a sole arbitrator and called upon the respondent to accept the nomination and come forward for resolution of the dispute. Full stop. However, although the respondent has received the notices, the respondent has not responded, and therefore the petitioner is before this court. Full stop. Next para. Though notice is served on the respondent, there is no representation. Full stop. Since there is no contest to the claim made by the petitioner, and since this court is satisfied, having gone through the material available on record, that the petitioner has complied with the requirements in terms of section 11 of the Arbitration and Conciliation Act, this court proceeds to pass the following order. More than 1 crore, is it? You want a high court judge or a district judge? Huh?
So in relation to fixed rents. The date of filing of.
We'll appoint Sri Nabirasul S. Mamdapur, retired district judge. Yes. Yes.
My lord, I appear. Lord, I appear, my lord. That matter is settled, my lord, out of court.
Learned counsel for petitioners. And the petitioners have filed a memo dated 10/14/7/2023, stating that the parties have amicably settled the matter. Therefore, the prayer made in the civil miscellaneous petition does not survive for consideration. Stop. The CMP stands disposed of in view of the settlement of the dispute between the parties.
Yes, great.
Appearing for the petitioner, my lord, filed a memo for withdrawal.
You have gone before the civil court?
My lord, the contract is not valid, my lord. There is no arbitration clause. There was a mistake in filing the.
The petitioner and learned counsel for petitioner have filed a memo dated 22/7/2023, stating that the petitioner has approached the
Is going to
civil
approach,
court,
man.
Bengaluru,
Is going to approach, man.
that the petitioner seeks to approach City Civil Court, Bengaluru, for redressal of its grievance. Full stop. Therefore, petitioner does not press the CMP.
Please.
Full stop. Next para. The memo is taken on record, subject to all just exceptions. Full stop. Accordingly, the CMP stands dismissed as withdrawn.
Grateful, man.
Bhandari.
Mr. Harish Bhandari. BBMP. Matters called out. There is no representation for the petitioner. So, although this writ petition was filed during September 2018, the office objections have not been complied till date. Stop. Next para. Read this matter on 9th of August 2023. Stop. If office objections are not complied by the next date of hearing, the writ petition will be dismissed.
Similar matter was aggregated. As against them, appeal is made, appeal is pending. In the case of the appeal, there is an order in another matter, there is an order. The result of the reality for payment of 50% of the demand. I only request the to last similar order in all these matters.
Reassessment.
Copy will be served, we are not to have tomorrow, have changes. Let's know this.
Learned counsel. PG Banu Prakash, appearing for the respondent BBMP, submits that under similar circumstances in WP number 1342 of 2023, by an interim order dated 19th of January 2023, stay of the demand notice was granted subject to the petitioner depositing 50% of the difference tax amount within a prescribed period. Full stop. Learned counsel submits that similar directions may be given to the petitioners. Full stop. Next para. However, learned counsels for the petitioners submit that they do not have a copy of the said order. What statement of this? You have filed statement of objections. Stop. Further, comma, it appears that the statement of objections have been filed at the hands of the respondent BBMP, and copies of the same have not been received by the learned counsels for petitioners. Full stop. Next paragraph. Consequently, release this matter on 2nd of August 2023. In the meanwhile, learned counsel for the respondent BBMP shall serve copies of the statement of objections and copy of the interim order dated 19th of January 2023, passed in WP number 1342 of 2023. Interim orders granted earlier stands extended.
Your Honor, I appear on behalf of the petitioners in serial number 20.17. I have filed a memo for withdrawal because my repetition has become infructuous.
20.17.
Petition number 20759 of
20.17.
17, please. Petition number 20759 of 2021. A memo for withdrawal was filed on 20.
Only in that one.
Please.
20.17 only. 20759 of 2021. Learned counsel for petitioner. Petitioners has filed a memo dated 22/7/2023 stating that after filing of this petition, a subsequent demand notice dated 1/6/2023 has been issued by the BBMP, and therefore the prayer made in this petition has become infructuous. Full stop. Therefore, it is prayed that the petitioner may be permitted to withdraw the petition.
With liberty, it may be accorded. It permitted
With liberty to challenge the subsequent demand notice dated 1/6/2023. Full stop. Next paragraph. Accordingly, the writ petition is dismissed as withdrawn, reserving liberty as prayed for. Huh? That each time is granted at the request of learned counsel for respondent number 3 to comply with the office objections raised on IA number 1 of 2023. Huh? Why are you wasting your time like this? Huh? If you have to go to the civil court, you please go get a declaration. What is the use of pending it like this? Can you withdraw the writ petition then? At the request of the learned counsel for petitioner, release this matter on 28th of July. Please take instructions and file a memo. Yes. This matter after service of notice on the respondent. Sarvagidiya. It has to come.
Well, my lord, they have conducted the auction. Tomorrow is the last date for confirmation. 3 days without it over.
See, if this court, huh?
The director wants ready to deposit 50% of the amount. The outstanding amount 26,65,000, which is borrowed with the husband.
No. Yes. Next matter, please.
24.
Memo ಹಾಕಿದ್ದೀರಾ? Please file. Twenty-four and 26. 39 avadana. Same.
24 and 2.
ಏನದು?
Regarding voting right.
ಆಯ್ತು, that is. Please file a memo. Learned counsel for the petitioner has filed a memo dated 26th of July 2023 stating that the petitioners were permitted to participate in the elections, and the prayer made in the writ petition has become infructuous. Stop. Consequently, it is prayed that the petition may be dismissed as withdrawn, dismissed as having become infructuous. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands disposed of as the prayer made in the writ petition has become infructuous. Same order. 26. 39. ಅದು ಬರ್ಲಿ ಹಂಗದ 39 ಬೇಡ. Yes. ಅದೇ 24 and 26 ಎರಡರಲ್ಲೂ ಮೆಮೊ ಹಾಕ್ಬಿಡಿ. Yes. A week's time is granted for compliance of office objections. Same order.
Not in the second prayer, directly respondent number 2, decide on the idea prior to the respondent number 4, under section 71(3) of the KCS Act. After affording opportunity to the petitioner.
ಕಾಪಿ ಹಾಕಿಲ್ಲ ಅಂತ.
ಅದು ಇಲ್ಲ, ಕಾಪಿ ಹಾಕಿ. It's an expired order. It's an expired order. I have not still applied for the certified copy. But the facts of this case, this case.
Alala, who filed that IA?
IA is filed by one of the defeated candidates.
Huh?
One of the defeated candidate before the assistant registrar. The facts are this. Election was conducted on 9/7/2023. On July, as per annexure, the declaration of results. Results were declared. But one of the respondent number 4, your Mr. Shetty, he files the election dispute. Now within IA for staying the declaration of the result. Not an expert entry model is granted, staying the declaration of results. In fact, not the president election was also scheduled on 20th. 17th they filed the election dispute along with an IA, and an entry model is granted. Still granting the final ruling, and declaration of result is stayed. But there are a number of judgments where it says elected representatives should not be restrained.
Where is that order?
Annexure, it starts from 40, annexure C. Is the operative force. ಫೆಬ್ರವರಿ ಸಂಘ ದಿನಾಂಕ 19/7/2023 ನಡೆದ ಆಡಳಿತ ಮಂಡಳಿಯ ಸದಸ್ಯ ಚುನಾವಣೆಗೆ ಎರಡನೇ ಪ್ರತಿವಾದಿಯು 3 ರಿಂದ 15ರವರೆಗೆ ಪ್ರತಿವಾದಿಗಳು ಆಯ್ಕೆಯಾಗಿರುತ್ತದೆ ಘೋಷಣೆ ಮಾಡಿದ ಚುನಾವಣಾ ಫಲಿತಾಂಶ ತಾತ್ಕಾಲಿಕವಾಗಿ ಮುಂದಿನ ವಿಚಾರಣೆಯಾಗಿ ತಡೆಯಾಗಿದೆ. And declare the president election was scheduled on 20th at annexure E. 17th dispute is filed and 17th expert entry order is granted.
Anyway, you please secure it and file it. You apply and secure it and file it.
I filed IA because I thought the second prayer could not therefore the officers. In fact, this copy the appeal copy I got it from the returning officer. When they postponed the election of the office bearer. In a day or two, I filed it. I sought to stay out because now
as regards the office objection, that copy of the interlocutory application filed at the hands of respondent number 4 herein. In dispute bearing number
353
of 2022-23, 23-24 before the first respondent, assistant registrar of cooperative societies, learned counsel would submit that in fact there is no mention of such an IA in the impugned order. Dated
he has filed the dispute on
17/7/2023 at annexure D, nevertheless, the petitioner would undertake to secure a copy of the IA, if filed by the 4th respondent, and produce the same before this court. Full stop. Nevertheless, next para. Learned AGA takes notice for respondent number 1 and 2. Issue emergent notice to response number 3 to 5. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that in a dispute raised under section 70 of the Karnataka Cooperative Societies Act of 1959. Which is in the nature of an election petition, calling in question an election conducted on 9/7/2023 to the board of the third respondent, Cooperative Society, the first respondent, Assistant Registrar of Cooperative Societies, has passed the impugned order staying the results that were announced on 9/7/2023. So, Learned Counsel submits such interim orders of stay of a declared results is not permissible in an election petition. Stop. In that view of the matter, there shall be an ad interim order of stay of the impugned order dated 17/7/2023 at Annexure D, till the next date of hearing. Matter is called out. There is no representation for the petitioner or for the respondent. We'll stop. Release this matter on 9th of August.
31.
Petitioner.
Yes.
Issue. In respect of the orders passed to the respondent municipality, then the sanction of the plan has been rejected. But the facts of this case are the property minutes was acquired by the petitioner. Prior to acquiring minutes, this layout plan was approved that your lordship finds on page number 18 minutes.
Yes.
Let's page number 18. Page number 18 is an approved.
Year 1 of 2020 for modification.
Has been disposed of.
Yes.
Kindly see page 18. Page 18 minutes is the sanctioned layout plan. The sanctioned layout plan was approved.
Sir, we are concerned with the construction that you have put up, and the contention of the municipality is that the construction is done without leaving the required setback, having regard to the building line of the road.
Right. That's what happened, my lord, was this was an existing major district road. This major district road, my lords, layout plan is approved. This layout plan, my lords, is approved in the year 1986. Now, my lords, when the layout plan is approved in the year 1986, the shops are, my lords, shown abutting this road. Those are the shops which I have purchased.
Now, my lords, in 2000, my lords, I obtained a sanction plan for putting up a cellar portion. Now, the sanction plan has been approved by the authorities. I have already.
Where is that sanction plan?
Lords, I produced it along with the memo, my lords.
No, but you had stated there is a deemed sanction.
Lords, that is
There was no sanction.
No, that is thereafter, my lords. This is the prelude, my lords, before. That is why I said, in 1986, the layout plan came. to be
Yes.
approved. Pursuant to that, I purchased sites.
Yes.
Which are, my lords, abutting the road. There are about 6 sites I purchased. Now, my lords, for putting up construction of a cellar, I obtained a sanction plan and license. as well.
When?
It was in 2000.
2000.
Correct.
Ah,
Now, I have already constructed the cellar portion. Not only me, my lords, all the persons who are abutting the road on this very particular road, I put up constructions as per the whatever plan or whatever, my lords, without leaving 6 meters from the building line. They have not followed it, my lords, because it was a major district road then. 2000, my lords, I constructed the cellar. If thereafter, my lords, in 2018, or I just, in 2009, my lords, this very same road came to be notified as a national highway. Yes. Now, my lords, by the time it was notified as a national highway, the construction of a cellar was already done. I wanted to put up construction of the ground and first floor. Now, my lords, this is the facts. Now, my lords, when I sought for approval of this, they are, my lords, they did not sanction or reject my application, my lords. Therefore, I assumed it to be a deemed sanction and therefore I put up construction. My lords, this is the facts. Now, my lords, my only request, my lords, is to appreciate that this road, my lords, which was not a national highway in 2002, I have already obtained plan and put up a cellar portion. Now, my lords, my cellar portion is already there existing. There is no dispute as regards.
where is that sanction plan?
The lordship directed me to produce it. I find it along with the memo. On 13/6/2023, 13/6/2000. The first document, my lords, is a sanction plan.
This is page number 2 that you're talking about.
But the entire road, my lords, is constructed much prior to this road being notified as a national highway. My lords, I have in fact produced photographs, my lords, of page 76, which show, my lords, that the entire road is constructed and nobody has left, in fact, a building line. My lords, in terms of the National Highway Act, my lords, whenever a road is notified as a national highway, my lords, they have to take into consideration the situation, my lords, as on the date when the properties are constructed or not to be. Now, assuming, my lords, that they want me to leave 15 meters as per their bylaws, my lords, the entire property that.
Now you have again sought for a building license, yes?
Yes, sir, I sought for a building license.
Now again.
Correct. That is for the ground and first floor, because I had already constructed the cellar. Therefore, I went for a sanction of building for ground and first floor.
Yes.
That is, my lords, wall on wall. Asking for something new. I want to put up construction of the cellar which is already in existence. Lords, that was, my lords, opposed by a stranger, a busybody of the village, who filed a writ petition, my lords, to say that I am putting up construction without a plan. He had obtained, my lords, order by the formal court, saying that if there is no plan, the authority should take action against me. On the very same day, my lords, I had also filed the writ petition, and very same court, my lords, granted a stay in my favor. My lords, my only submission, my lords, is this road, my lords, which is being declared as a national highway, my lords, inspections now. There is a bypass road already made. My lords, I'm just examining, my lords.
No, but please understand, provision is there in the Karnataka Municipal Corporations Act, Municipalities Act, and the Gram Panchayat Act, where even for alteration of a building and for further construction, you have to obtain building license. Therefore, when you have now filed an application seeking permission to put up first floor, second floor. Yeah, at that point of time also, they are required to insist on the setbacks. Therefore, you cannot find fault with them. Yes.
Only seeking for some indulgence and adjournment.
Yes.
For a fact, my lord, that there is a bypass road is already made.
No.
I understand, my lord. No,
Yeah,
that's-
but it is irrelevant whether this is a national highway or not. That is not important. That is why I didn't mention anything about the national highway. Any road for that matter. In any road for that matter, you are required to leave setbacks, isn't it? Whether it is a national abutting the national highway or any other crossroad. In every property, you are required to leave a certain setback. So therefore, when you have now filed an application, are they not entitled to say, no, you are required to leave this setback. So if you remove that one and show the setbacks, we will permit you.
That is why, my lord, I said, now, my lords, their contention is that this is a national highway. The building line that has to be construction. has-
Sir, you forget about it being a national highway.
They are saying.
Irrespective of that, sir.
But if it is a national highway, my lords, the setback area or the building line would be larger, would be more, would be larger. If it is as per the municipality, right, it would be smaller. That is what I want.
Please understand, what I am trying to say is, since you are already permitted to put up the cellar floor and you have put up, and you are now saying you will only raise the walls on top of that one, that which will be in consonance with the plan already sanctioned by the very same municipality. However, there is no setback.
No, my lords, as per, I will not.
Please understand, there is no setback because you have put up the shops, though they may be put up long ago. But while considering your application for a modified building plan, they are still required to insist for leaving the setbacks.
Correct.
So if not in the as per the requirement of the National Highways Act, even under the normal law, they are eligible to insist that you have to leave the setback. But since they have already sanctioned the plan permitting you to put up the cellar floor, you will be permitted to put up the first and second floor,
That's all I must.
provided you remove the shops. Because there
On facts is not correct. Can you see what they are submit application for? No, the application.
Page number?
And it's a lease file,
Page number,
page number 40 of the petition. And it's a lease file, on 2/8/2018. Yes, given date in the petition, not in the application. Page 40. ಸೌಭಾಗ್ಯ ಕಟ್ಟಡ ಅಸ್ತಿತ್ವದಲ್ಲಿದೆಯೇ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಕಟ್ಟಡ ಪರವಾನಗಿ ಸಲ್ಲಿಸುವುದು ನೆಲ ಹಕ್ಕಿಗೆ ಈ 2018 ಕೇಳ್ತಾರೆ ಅವರು ಸೆಲ್ಲರಿಗೆ. ನೋ ಸೆಲ್ಲರ್ ದೇರ್. 2018 ಫಾರ್ ದ ಫಸ್ಟ್ ಟೈಮ್ ದೇ ಆರ್ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಸೆಲ್ಲರ್.
2018
and 2000 ಕೊಟ್ಟಿದ್ದು ಅವ್ರು ಏನ್ ಮಾಡಲಿಲ್ಲ, ಅವರು ಅಥವಾ ಲ್ಯಾಪ್ಸ್ ಆನ್ ಇಟ್ಸ್ ಓನ್ 1 year permission ಇತ್ತು 2000.
So they have not put up.
ನೆಲ ಹಕ್ಕಿಗೆ ಈ ಕೇಳ್ತಿರೋದು 2018 ಫಾರ್ ದ ಫಸ್ಟ್ ಟೈಮ್ ದೇ ಆರ್ ಫೈಲ್ಡ್ ಫಾರ್ ಸೆಲ್ಲರ್.
That may be a mistake in the application, but we have taken a plan, we have constructed the shop. Right, the license is also there.
All right, where are your taxpayer receipts? From the year 2000, if you have put up the cellar floor and if you have paid the tax for that one, you please show.
Not filed it, but can I get a violation?
Correct.
This was not, in fact, it is not the objections of the other section. Now only they are saying this. I will produce it.
Contrary to law.
Learned counsel for the petitioner. submits that the petitioner obtained a sanction plan, way back in the year 2000 to put up a cellar floor in the property in question. However, since a copy of such sanction plan was not furnished along with the writ petition, the petitioner was called upon to furnish a copy. Accordingly, the petitioner, Learned Counsel for Petitioners, has filed a memo dated 13/6/2023 along with copy of the sanction plan. It is the contention of the petitioner that the petitioner is now seeking building license to put up the ground floor, first floor, and second floor. Next para. However, Learned Counsel Sri D. Nagaraj, appearing for the respondent municipality, submits that even if it is true that the petitioner had obtained a sanction plan in the year 2000 to put up a cellar floor, nevertheless, the construction was not put up. To substantiate his argument, Learned Counsel for the respondent municipality has drawn the attention of this court to the applications filed by the petitioner at Annexures E series and submits that the petitioner has clearly stated in the application that there is no existing construction and the petitioner is seeking permission to put up basement and additional floors. Full stop. Next para. The petitioner is required to furnish copies of the taxpayer receipts to show that he had put up construction of the cellar floor in terms of the sanction plan granted in the year 2000. Full stop. If the petitioner fails to furnish such information, then the submission of the Learned Counsel for the respondent municipality has to be accepted as correct. Full stop. Next para. Release this matter on 2nd of August. Interim order granted earlier stands extended till the next date of hearing.
Number 1, and from the PM.
Coming up for the first time or announced? No relief can be given.
Like in this matter, since from 1992.
Sir, once calendar of events are announced, no court can interfere. No orders can be passed. Berkeley. Learned HCGP takes notice for all the respondents. Next para. Learned Additional Advocate General, appearing for the petitioners, for the respondents, submits that the petitioner is raising a challenge to the impugned notification dated 26/6/2023, wherein reservation is provided to various posts of the adhyakshas and upadhyakshas of the gram panchayats.
But much prior to that, we file and we are also not receiving that calendar.
Sari aito. See, at the time of filing of the writ petition, maybe the calendar of events were not announced.
Not.
But if it is a fact that it is announced,
Appearing for the respondent submits that the petitioner is raising the challenge to the impugned notification dated 26/6/2023, wherein reservation is provided to various posts of adhyaksha and upadhyaksha of the gram panchayats.
in Chintamani Taluk. So, however, calendar of events have been announced. Stop. In that view of the matter, it is submitted that no relief can be granted to the petitioner. Stop. Aidan ತರ್ಸ್ಕೊಳ್ರಿ ಅವತ್ತೊಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ರಲ್ಲ ಪೊನ್ನು ಸ್ವಾಮಿ ಪಾಸ್ ಔಟ್ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಅಪ್ at 2:30. Yes. ಕೊಟ್ಟಿದ್ರಾ ತರ್ಸ್ಕೊಳ್ಳಿ. Yes. You are ready with the information.
Gram Panchayat. It put it yes, women in last previous. But 6 serial number. Number 28. Last time BCM A, this is BCM B. This is the same repeat time.
ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರಿ?
ಈ ಸರಿ BCM B ಅಧ್ಯಕ್ಷ, BCM A ಮಹಿಳೆ ಉಪಾಧ್ಯಕ್ಷ. Number 32.
BCM B
ಅಧ್ಯಕ್ಷ. BCM A ಮಹಿಳೆ ಉಪಾಧ್ಯಕ್ಷ. Petitioner is the SC women. 93 to till today. SC women is not.
Yes.
ಈ ಸರಿ ಏನು ಪಟ್ಟಣಗೆರೆಗೆ ಪ್ರಸಿದ್ಧ ಮಹಿಳೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಫಸ್ಟ್ ಟೈಮ್ ಪೇಜ್ ನಂಬರ್ 31 ಮೇಲೆ ಅಂಡ್ ದೆನ್ ಸೆಕೆಂಡ್ ನಂಬರ್ 8 ಫಸ್ಟ್ ಜಾತಿ ಮಹಿಳೆ ಸೆಕೆಂಡ್ ಟರ್ಮ್ ಕೊಡ್ತಾರೆ. ಸೆಕೆಂಡ್ ಟರ್ಮ್ ಕೊಡ್ತಾರೆ ಅವರಿಗೆ, ನಮಗೆ ಕನ್ಸರ್ನ್ ಕೊಡ್ತಾರೆ. ನಂಬರ್ 8 ಫಸ್ಟ್ ಜಾತಿ ಮಹಿಳೆ ನಂಬರ್ 31 ಮೇಲೆ.
SC female was given in year 2015.
No. No.
ಅಲ್ಲ serial number 8 ಅಲ್ಲಿ.
Serial number 8 ಅಲ್ಲ. I am for the challenging serial number 46.
ನಿಡ್ಗಟ್ಟ. ಇವಾಗ serial number 8 ಏನೋ ಹೇಳಿದ್ರೆ.
ಅಲ್ಲ ಅವರಿಗೆ ಸೆಕೆಂಡ್ ಟರ್ಮ್ ಥರ್ಡ್ ಟರ್ಮ್
ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಸೆಕೆಂಡ್ ಟರ್ಮ್ serial number 8.
serial number 8 ಅಲ್ಲಿ
ಜಾತಿ ಮಹಿಳೆ
ಈ ಸರಿ SC female ಕೊಟ್ಟಿದ್ದಾರಾ?
ಸೆಕೆಂಡ್ ಟರ್ಮ್
SC female.
ಪೇಜ್ ನಂಬರ್ 31 ಬಳಿಗನೂರು ಪರಿಸ್ಥಿತಿ ಜಾತಿ ಮಹಿಳೆ ಸೆಕೆಂಡ್ ಟರ್ಮ್ ಅವರಿಗೆ
ಬಳ್ಳಿಗನೂರು.
ಬಳಿಗನೂರು ಅಂಡ್ ದೆನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 22 ಅವರಿಗೆ ಥರ್ಡ್ ಟೈಮ್ ಫಸ್ಟ್ ಜಾತಿ ಮಹಿಳೆ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ನಂಬರ್ 8
ಇಲ್ಲ ರೀ, ಬಳ್ಳಿಗನೂರು BCM A ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ 2015 ಅಲ್ಲಿ ಫಸ್ಟ್ ಜಾತಿ ಮಹಿಳೆ
ಈ ಸರಿ ನೀವ್ ಹೇಳಿದ್ದು ರಿಪೀಟ್ ಮಾಡಿದಾರೆ SC ಅಂತ. ಇಟ್ ಇಸ್ ನಾಟ್ ಸೊ.
ಅಲ್ಲ 2015 ಅಲ್ಲಿ ಫಸ್ಟ್ ಜಾತಿ ಮಹಿಳೆ
ಆಯ್ತ್ರಿ, ಈ ಸರಿ ಇಲ್ಲ. ಇಟ್ ಇಸ್ ನಾಟ್ ಗಿವನ್ ದಿಸ್ ಟೈಮ್.
2015 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು ಮತ್ತೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಈ ಸಲ.
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ?
2015 ಅಲ್ಲಿ ಬಡಿ ಸೀರಿಯಲ್ ನಂಬರ್ 8
2015 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಯಾವ್ದಕ್ಕೆ?
ಜಾತಿ ಮಹಿಳೆ
ಪಳ್ಳಿಗನೂರ್ಗೆ SC ಫಿಮೇಲ್ ಕೊಟ್ಟಿದ್ರು. ಹೌದು.
ಈ ಸಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಉಪಾಧ್ಯಕ್ಷಿಗೆ.
ಉಪಾಧ್ಯಕ್ಷ ಬೇರೆ. ಯು ಕಾಂಟ್ ಕಂಪೇರ್ ದಿ ಟು. ದಿ ಸಿಸ್ಟಮ್ ಇಸ್ ಡಿಫ್ರೆಂಟ್. ಈ ಸರಿ ಉಪಾಧ್ಯಕ್ಷಗೆ SC ಫಿಮೇಲ್ ಕೊಟ್ಟಿದಾರಾ? SC ಫಿಮೇಲ್ ಆಯ್ತು.
ಸೀರಿಯಲ್ ನಂಬರ್ 22 ತಂಗಡಿ
22.
ಫಸ್ಟ್ ಜಾತಿ ಮಹಿಳೆ ಉಪಾಧ್ಯಕ್ಷ.
SC ಫಿಮೇಲ್
ಫೀಮೇಲ್
ಉಪಾಧ್ಯಕ್ಷ. ಆಯ್ತು. ಅಧ್ಯಕ್ಷದವರಿದ್ರೆ ತೋರಿಸಿ.
ಅಧ್ಯಕ್ಷ 25 ML ಅದು ಉಪಾಧ್ಯಕ್ಷ.
ಉಪಾಧ್ಯಕ್ಷದವರು ಆಗೋದಿಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಮೇಲೆ ಎಸ್ ಮಾದಾಪುರ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಮಹಿಳೆ.
ಯಾವ್ದಕ್ಕೆ?
ಅಧ್ಯಕ್ಷ.
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಇಟ್ ವಾಸ್ ಗಿವನ್ ವಾಸ್ ಓನ್ಲಿ ಇನ್ 2000.
ನನಗೆ 93 ಇಂದ ಟುಡೇ ಒಂದು ಸಿಂಗಲ್ ಕೊಟ್ಟಿಲ್ಲ. ಅವ್ರಿಗೆ ಸೆಕೆಂಡ್
ಸರಿ SC ಕೊಟ್ಟಿದಾರಾ?
ಅಲ್ಲ, ಈ ಸಲ ಕೊಟ್ಟರು 46 ಗೆ BCM B ಅಧ್ಯಕ್ಷ, BCM A ಮಹಿಳೆ.
ಅಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಮಾದಾಪುರಕ್ಕೆ
37 ಗೆ
SC
ಜಾತಿ ಮಹಿಳೆ,
SC ಫಿಮೇಲ್. ಆಮೇಲೆ ಉಪಾಧ್ಯಕ್ಷಗೆ
BCM B.
ಸೊ ಅವ್ರಿಗೆ 2000 ಅಲ್ಲಿ ಬಂದಿತ್ತು, ಮತ್ತೆ ಈ ಸರಿ ಬಂದಿದೆ ಅಂತ ನೀವು ಹೇಳ್ತಾರೆ.
ನನಗೆ ಒನ್ ಟರ್ಮ್ ದೆನ್ ಮೈ ಲಾರ್ಡ್ ಸೀರಿಯಲ್ ನಂಬರ್ 47
ಬಂದಿದ್ಯಲ್ರಿ.
SC SC ವುಮೆನ್
ಬರಲ್ಲ.
ಅಲ್ಲ, SC ವುಮೆನ್
ದೇರ್ ಮೇ ಬಿ ಸಮ್ ಅದರ್ ರೀಸನ್ ಫಾರ್ ದಟ್. ಹಿಂಗಾಗೋದಿಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್ 47 ಉಲ್ಲೇಖರಿಗೆ ಫಸ್ಟ್ ಜಾತಿ ಮಹಿಳೆಗೆ ಥರ್ಡ್ ಟೈಮ್ ಕೊಡ್ತಾರೆ.
ಥರ್ಡ್ ಟೈಮ್ ಇಲ್ರಿ, ಸೆಕೆಂಡ್ ಟೈಮ್ ರೀ.
47 ಸೀರಿಯಲ್ ನಂಬರ್.
It was given in 2000 and this time it has come.
2000 ಅಲ್ಲಿ ಫಸ್ಟ್ ಜಾತಿ ಮಹಿಳೆ.
ಅದೇ ಕರೆಕ್ಟ್.
ಅಂಡ್ ದೆನ್ ಮೈ ಲಾರ್ಡ್ ಫಸ್ಟ್ ಜಾತಿ ಮಹಿಳೆ ಉಪಾಧ್ಯಕ್ಷ 2010 ಅಲ್ಲಿ.
ಉಪಾಧ್ಯಕ್ಷ ಈ ಎರಡಕ್ಕೂ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಬೇಡಿ ದಯವಿಟ್ಟು.
ನಮಗೆ ಒಂದ್ಸರಿ
ಬಂದಿದೆ ರೀ ನಿಮ್ಗೆ ಅದಾದ್ಮೇಲೆ 2005 ಅಲ್ಲಿ ಬಂದಿದೆ. ಸೊ ಸೈಕಲ್ ಎಷ್ಟು ಕಂಪ್ಲೀಟ್, ಪ್ಲೀಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಎಷ್ಟಮ್ಮ ಹೌ ಮೆನಿ ಗ್ರಾಮ ಪಂಚಾಯತ್? ಗ್ರಾಮ ಪಂಚಾಯತ್. SC ಎಷ್ಟು? 8 scheduled caste, 1 scheduled tribe, 16 31 general. ಇದೆ. See, 8 reservations are there. It has to go in a cycle for 60 gram panchayats. ಎಷ್ಟಾಯ್ತು ಅಲ್ಲಿಗೆ? 6, 7 minimum 7 terms have to go for completion of the cycle. ನಿಮಗೆ 2005 ಅಲ್ಲಿ ಬಂದಿದೆ. ಅದಾದ್ಮೇಲೆ 1, 2, 3, 4, 5 ಇದು 6ನೇ ಟರ್ಮ್. ಸೊ ಸೈಕಲ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ ಇನ್ನು. ಈ 7ನೇ ಟರ್ಮ್ ಆದ್ಮೇಲೆ 8ನೇ ಟರ್ಮ್ಗೆ ಪ್ರಾಬಬ್ಲಿ ಯು ಮೇ ಗೆಟ್ ಇಟ್. ಅದೇ ಅವಾಗ ಅದನ್ನ ವಿ ಆರ್ going to consider that in other batch of writ petitions. Let us see. The petitioner who is a member of Nidagatta Gram Panchayat of Kadur Taluk is aggrieved of the impugned notification issued by the third respondent, deputy commissioner, come election officer. Starting a learned AGA takes notice for learned HCGP takes notice for response number 1 and 3. Learned counsel Srimati Vaishali Hegde takes notice for response number 2. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on learned counsel for response number 2 and a copy on the learned HCGP. We'll stop. ಆಮೇಲೆ ಇದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀವಿ. Next para. Learned counsel for the petitioner submits that although there are two posts, two members from the scheduled caste community in the Gram Panchayat, nevertheless, reservation of scheduled caste female was never given to the Gram Panchayat. So, on the other hand, it is submitted that although SC female reservation was given to Balliganuru Gram Panchayat in the year 2015, nevertheless, again, reservation of SC female is given to the post of Upadhyaksha in the impugned notification. Stop. Similarly, in Tangali Gram Panchayat, in the previous term, SC female reservation was given to the post of Adhyaksha, and this time SC female reservation is given to the post of Upadhyaksha. Stop. Further, it is submitted that there has been an exchange of the post, exchange of reservation given to Nidgatta, when compared to the previous term. Stop. It is submitted during the first term of the elections in the year 2020. The post of Adhyaksha was reserved for BCM-A female category and Upadhyaksha was reserved for BCM-B female category. Full stop. This time, the post of Adhyaksha is reserved for BCM-A, BCM-B category and Upadhyaksha is reserved for BCM-A female category. Full stop. Next para. Learned Additional Advocate General submits that the Taluka has got 60 Gram Panchayats, out of which 8 posts of the Adhyaksha are reserved for scheduled castes, 1 for scheduled tribe, 16 for BCM-A, 4 for BCM-B, and 31 for general category. Stop. It is submitted that in terms of the guidelines issued by the State Election Commission, which is in the nature of a government order dated 25/5/2023, the Deputy Commissioner is required to commence the rotation from the category of scheduled castes comma, followed by scheduled tribes, comma, thereafter BCM A, followed by BCM B, and the remaining is to be rotated in the general category. Stop. Having regard to the number of posts available for the scheduled castes, that is 8, and the number of gram panchayats, that is 60, comma, the learned AAG would submit that arithmetically it would take more than 7 terms for repeating the reservation of scheduled caste for a gram panchayat. Full stop. In that view of the matter, comma, it is submitted that since Nidgatta Gram Panchayat had a reservation of SC category in the year 2005, bracket only first term, comma, and this elections being the 6th term after 2005, bracket only first term, comma, the petitioner cannot expect the repetition of scheduled caste category reservation to the Gram Panchayat. Full stop. Next para. Moreover, comma, it is submitted. Either the GPP, VP and the paragraph. Next para. Having heard the learned counsel for petitioner, comma, the learned AAG, and on perusing the petition papers, comma, this court is of the considered opinion that the respondent deputy commissioner has followed the guidelines and no fault can be found in the impugned notification. Full stop. Next para. Consequently, the petition stands dismissed.
Then 1994, there was no.
I'll take a short break. I'll come back.
ಆಫೀಸರ್ ಈಗ ಆಗಿದ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಅಲ್ವಾ? ಹಲೋ ಹಲೋ
ಸರ್ ಬರ್ತಾರೆ ಸರ್.
ಅಲ್ಲ ಈಗ ಈಗ ಆಗಿದ್ದು ಎರಡನೇದಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಅಲ್ವಾ
ಸರ್? ಸೀರಿಯಲ್ ನಂಬರ್ 3
ಆಯ್ತಾ? ಈಗ ಆದ್ರೆ ನಂದು 4 ನಂದು ಅದಕ್ಕೆ
ಸರ್. ಇಲ್ಲ ಇಲ್ಲ, ಈಗ 2 ಆಗಿದ್ದು.
2 ಆಗಿದ್ದಲ್ವಾ? ಸೊ 3 ನಂದು 4 ಇದೆ. ಸರಿ, ಓಕೆ. ಐ ವಿಲ್ ವೇಟ್.
ಓಕೆ ಓಕೆ ಓಕೆ.
ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ನಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಇತ್ತು, ಏನಾಗಿದೆ
ಸರ್? ಒಂದು 2 minutes ಬರ್ತಾರೆ ಇರಿ ಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್.
ನಾನೇ ಇದ್ದೀನಿ ಅಂತ
ನೀವು ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಲ್ಲ ಸರಿ
Yes. Then we will cut. Reservation to the question, not transfer.
Calendar of events. Huh?
Annexure R. And annexure G. There is no reservation to the main category.
Huh?
Main category should cut.
But once calendar of events are announced, we cannot consider. Is a calendar of events. Once calendar of events are announced, we cannot consider. No court can interfere. You should have done it before. Berkeley. ಅದಲ್ರಿ ನಾನ್ ಮೊನ್ನೆ ಒಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತೇನ್ರಿ. ಹಾ ಸೇಮ್ ಆರ್ಡರ್ ಕೊಟ್ಬಿಡಿ. Calendar of events announced on 18/7/2023 in the form of a meeting notice, election notice at annexure R. Same orders. Paradilla, we can't consider once calendar of events are announced, no court can interfere on the merits of the matter also. That could be considered only prior to the issuance of the calendar of events. Once calendar of events are announced, no court will interfere. Yes.
I appear for the respondent number 14, my lord. In this
Yes.
matter, day before yesterday, a report was for learned advocate general was placed. I got the copy. Please,
Yes.
please peruse that, my lord. In fact, several points were raised to be decided by the court at the ಬರ್ದಿದ್ದಾರೆ ಅದರಲ್ಲಿ. ಸ್ವಲ್ಪ your lords may kindly consider that.
Yes.
Of course, ತಪ್ಪಾಗಿ ಅವರು 15th 23/5 ಅಂತ ಹಾಕಿದ್ರು. Actually 27th ಅದು ರಿಪೋರ್ಟ್.
correct.
ನೋಡಿ ಪೇಜ್ 1 ಅಲ್ಲಿ ಪಾರ 3 ಅಲ್ಲಿ ನೋಡಿ. Your lordship got that file.
Yes.
ಮರು ಎಣಿಕೆಯಂತೆ ಮತಗಟ್ಟೆ 248ರಲ್ಲಿ ನಾಗರತ್ನ ಸೊ ಎಂಬುವರಿಗೆ 321 ಮತಗಳು ಹಾಗೂ ಸವಿತಾ ಅವರಿಗೆ 300 ಮತಗಳು ಕ್ರಮಬದ್ಧವಾಗಿರುತ್ತದೆ. ಹಾಗೂ ಮತಪತ್ರ 199 ಮತ್ತು 501ರಲ್ಲಿ 2 ಮತಪತ್ರಗಳು ಸಂಶಯಾಸ್ಪದವಾಗಿದ್ದು ಸದರಿ ಮತಪತ್ರಗಳನ್ನು ಅಂಗೀಕಾರ ಅಥವಾ ತಿರಸ್ಕೃತ ಎಂಬ ಬಗ್ಗೆ ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ತೀರ್ಮಾನಿಸುವುದಾಗಿ ಉಭಯ ಅಭ್ಯರ್ಥಿಗಳು ಹಾಗೂ ವಕೀಲರು ತಿಳಿಸಿರ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಪಾರ ಮರುಮತ ಎಣಿಕೆ ಮತಗಟ್ಟೆ ಸಂಖ್ಯೆ 249ರಲ್ಲಿ ನಾಗರತ್ನ ನಂಜುಂಡೇಗೌಡ ಎಂಬುವರಿಗೆ 258 ಮತಗಳು ಹಾಗೂ ಸವಿತಾ ಅವರಿಗೆ 282 ಮತಗಳು ಕ್ರಮಬದ್ಧವಾಗಿರುತ್ತದೆ. ಮತಪತ್ರ 840, 977, 1139 ಮತ್ತು 1268 4 ಮತಪತ್ರಗಳು ಸಂಶಯಾಸ್ಪದವಾಗಿದ್ದು ಸದರಿ ಮತಪತ್ರಗಳನ್ನು ಅಂಗೀಕಾರ ಅಥವಾ ತಿರಸ್ಕೃತ ಎಂಬ ಬಗ್ಗೆ ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ತೀರ್ಮಾನಿಸುವುದಾಗಿ ಉಭಯ ಅಭ್ಯರ್ಥಿಗಳು ಹಾಗೂ ವಕೀಲರು ತಿಳಿಸಿರ್ತಾರೆ ಎಂದು ಹಾಗೂ ತಿಳಿಸಿರ್ತಾರೆ. ಹಾಗೂ ಅಂಚೆ ಮತಪತ್ರದ ಮೂಲಕ ನಾಗರತ್ನ ನಂಜುಂಡೇಗೌಡ ಎಂಬುವರಿಗೆ 1 ಮತ ಹಾಗೂ ಸವಿತಾ ಎಂಬುವರಿಗೆ 2 ಮತಗಳು ಕ್ರಮಬದ್ಧವಾಗಿವೆ. ಅಭ್ಯರ್ಥಿ ನಾಗರತ್ನ ನಂಜುಂಡೇಗೌಡ ಅವರಿಗೆ ಒಟ್ಟು 579 ಪ್ಲಸ್ 580 ಮತ್ತು ಮತಗಳು ಬಂದಿರುತ್ತದೆ. ಅಭ್ಯರ್ಥಿಯಾದ ಸವಿತಾ ಅವರಿಗೆ 581 ಪ್ಲಸ್ 2 584 582 ಪ್ಲಸ್ 2 ಕರೆಕ್ಟ್ 584 ಮತಗಳು ಪಡೆದಿರುತ್ತಾರೆ. ಮುಂದುವರಿದು ಮೇಲ್ಕಂಡ ಸಂಶಯಾಸ್ಪದ ಮತಪತ್ರಗಳನ್ನು ಈ ಕೆಳಗಂಡ ಕಾರಣಗಳಿಂದ ಅಂಗೀಕಾರ ಅಥವಾ ತಿರಸ್ಕೃತಗೊಳಿಸಬಹುದು. This is the opinion. This is what he has left it for to be decided by the court. One item. Another, my lord, there are about 6 items they have mentioned. In that, earlier what was rejected, here it is accepted. In some of them, it's to be accepted or not to be accepted. Ultimately, it is left to the court at the brother report hakidare. Anyway, I'm not if the court has to decide about this, how it could be decided without seeing the voters that 6 items or whatever the votes.
No. We are directed you to get all the ballot papers. It is bad. You have brought it. Yes. ಮತಗಟ್ಟೆ ಸಂಖ್ಯೆ 248ರಲ್ಲಿ ಮತಪತ್ರ ಸಂಖ್ಯೆ 199ರ ಮತಪತ್ರವನ್ನು ಈ ಹಿಂದೆ
ಸಾರ್ವಜನಿಕ ಚುನಾವಣಾ ಮತಗಳಿಗೆ ಅಂಗೀಕರಿಸಲಾಗಿದ್ದು ಮರು ಎಣಿಕೆಯಲ್ಲಿ ಸದರಿ ಮತಪತ್ರದಲ್ಲಿ ಖಾಲಿ ಜಾಗದಲ್ಲಿ ಗುರುತು ಮಾಡಿರುವುದರಿಂದ ಮಾರ್ಕ್ ಇನ್ ಬ್ಲಾಂಕ್ ಏರಿಯಾ ಎಂದು ಪರಿಗಣಿಸಿ ತಿರಸ್ಕರಿಸಬಹುದು. This is opinion. ನೆಕ್ಸ್ಟ್ ಮತಗಟ್ಟೆ 248
ಅಲ್ಲ, ಇಟ್ ಇಸ್ ಮಾರ್ಕ್ಡ್ ಇನ್ ಬ್ಲಾಂಕ್ ಏರಿಯಾ. ಸೊ ಯಾರಿಗೆ ವೋಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಾಗೋದಿಲ್ಲ.
ಹೌದು.
So therefore it has to be rejected.
Yes, I'll one minute, my lord. I will consider these 6 items and then I leave your lordship to deal with the matter.
Yes.
ಮತಗಟ್ಟೆ 248ರಲ್ಲಿ ಸೇಮ್ ಮತಗಟ್ಟೆ ಮತಪತ್ರ 511ರ ಮತಪತ್ರವನ್ನು ಈ ಹಿಂದೆ ಸಾರ್ವಜನಿಕ ಮತ ಎಣಿಕೆಯಲ್ಲಿ ಅಂಗೀಕರಿಸಲಾಗಿದ್ದು ಮರು ಎಣಿಕೆಯಲ್ಲಿ ಸದರಿ ಮತಪತ್ರದಲ್ಲಿ ಹೆಬ್ಬೆಟ್ಟಿನ ಗುರುತು ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಮಾರ್ಕ್ ನಾಟ್ ಮೇಡ್ ವಿತ್ ದಿ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಸಪ್ಲೈಡ್ ಎಂದು ತಿರಸ್ಕರಿಸಬಹುದು. This is his opinion.
Correct.
249ರ ಮತಪತ್ರ 840ರ ಮತಪತ್ರವನ್ನು ಈ ಹಿಂದೆ ಸಾರ್ವಜನಿಕ ಚುನಾವಣೆಯ ಮತ ಎಣಿಕೆಯಲ್ಲಿ ಹಲವು ಜನರಿಗೆ ಮತ ಮಾಡಿದೆ ಎಂದು ತಿರಸ್ಕರಿಸಲಾಗಿದ್ದು, ಮರು ಎಣಿಕೆಯಲ್ಲಿ ಸದರಿ ಮತಪತ್ರ ಹಿಂಭಾಗದಲ್ಲಿ ಮತಗಟ್ಟೆಯ ಮೊಹರು ದಾಖಲಿಸಿರುವುದು ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿರುವುದರಿಂದ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಕ್ರಮಬದ್ಧವಾಗಿದೆ ಎಂದು ಅಂಗೀಕರಿಸುವುದು. ಅಂದ್ರೆ ಮೊದಲು ರಿಜೆಕ್ಟೆಡ್, ಈಗ ಅಂಗೀಕರಿಸಬಹುದು ಅಂತ ಹೇಳ್ತಾರೆ.
ಹಿಂಭಾಗದಲ್ಲಿ ಮತಗಟ್ಟೆಯ ಮೊಹರು ದಾಖಲಿಸುವುದು
ರಿಫ್ಲೆಕ್ಟ್
ಆಗಿರುವುದು
ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಕ್ರಮಬದ್ಧವಾಗಿದೆ ಎಂದು ಅಂಗೀಕರಿಸಬಹುದು ಅಂತ ಹೇಳ್ತಾರೆ. ಮೊದಲು
ಅಂದ್ರೆ ಅರ್ಲಿಯರ್ ಇಟ್ ವಾಸ್ ರಿಜೆಕ್ಟೆಡ್ ಬಿಕಾಸ್
ಹಲವು ಜನರಿಗೆ ಮತ ಮಾಡಿದೆ ಅಂತ.
they were suspicious. No, they were suspicious whether it was a ballot paper issued by the authority. Now it is found
ಅದರ ಕಾರಣ ನೋಡಿ,
that the seal.
ಇಲ್ಲ, ಈ ಹಿಂದೆ ಸಾರ್ವಜನಿಕ ಚುನಾವಣೆ ಮತ ಎಣಿಕೆಯಲ್ಲಿ ಹಲವು ಜನರಿಗೆ ಮತ ನೀಡಿದೆ ಎಂದು ತಿರಸ್ಕರಿಸಲಾಗಿದ್ದು. ಮಲ್ಟಿಪಲ್ ಐಟಮ್ ನಂಬರ್ 3 ಓದ್ತಾ ಇದ್ದೀನಿ. ಹಲವು ಜನರಿಗೆ ಮತ ನೀಡಿದೆ ಎಂದು ತಿರಸ್ಕರಿಸಲಾಗಿದ್ದು, ಮರು ಎಣಿಕೆಯಲ್ಲಿ ಸದರಿ ಮತ ಸೋದರಿ ಹಲವು ಜನರಿಗೆ.
Please show the original.
Now I'll read those items.
I will let us see the original, sir. We have it here.
One by one ತಾವು ನೋಡಿ ತಮಗೆ ಬಿಟ್ಟಿದ್ದೀನಿ.
ಅಲ್ಲ, first 1 and 2 it is clear. It cannot be accepted. See, because mark is made in the blank area. It cannot be accepted. ಯಾರಿಗೆ ಮತ ಹಾಕಿರೋದು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅದರಲ್ಲಿ. So it cannot be accepted.
It has to be rejected.
ಎರಡನೇದು mark not made with instrument supplied. ಹೆಬ್ಬೆಟ್ ಹಾಕಿದ್ದಾರೆ. ಹೌದು,
ಇದನ್ನು ತಿರಸ್ಕರಿಸಿದ್ದಾರೆ.
ಹೌದು,
ಸರಿ, ಎರಡಾಯ್ತು.
ಇವಾಗ ಮೂರನೇದಲ್ಲಿ we have that original here with in the court.
Your lordship peruse it. I just leave it to your lordship. ಈ ಹಿಂದೆ ಹಲವು ಜನರಿಗೆ ಮತ ನೀಡಿದೆ ಎಂದು ತಿರಸ್ಕರಿಸಲಾಗಿತ್ತು.
Correct. So it has to be rejected. See here, ಇಲ್ಲಿ ನೋಡಿ please.
ಈಗ ಅವರು ಹೇಳೋದು ಅಂಗೀಕರಿಸಿ ಅಂತ.
ಇಲ್ಲ, ಅಂಗೀಕರಿಸಕ್ ಆಗೋದಿಲ್ಲ.
ಅದು ಅಂಗೀಕರಿಸಕ್ ಆಗೋದಿಲ್ಲ.
ಇಲ್ಲಿ see, because marking is made to 1, 2, 3, 4, 5 candidates. ನೋಡಿ, ತೋರಿಸ್ರಿ ಅವ್ರಿಗೆ 5 ಕ್ಯಾಂಡಿಡೇಟ್ ಗೆ ಮಾರ್ಕಿಂಗ್ ಮಾಡಿದ್ದಾರೆ.
ಇವರ ಒಪಿನಿಯನ್ ಅಂಗೀಕರಿಸಬಹುದು ಅಂತ.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ, ಅದು ಬರೋದಿಲ್ಲ. ಸೊ that is also rejected.
ಅದು ಅಂಗೀಕರಿಸಬಹುದು ಅಂತ ಲೆಕ್ಕಕ್ಕೆ ತಗೊಂಡಿದ್ದಾರೆ.
ಇಲ್ಲ, it cannot be.
ಹೌದು, ಮೂರನೇದು ಹೋಗುತ್ತೆ.
ಕೊಡ್ಲಿ ಅವ್ರಿಗೆ ವಾಪಸ್.
ರಿಜೆಕ್ಟ್ ಆಗಿತ್ತು, ಆಕ್ಚುಲಿ ಮೊದಲು ರಿಜೆಕ್ಟ್ ಆಗಿತ್ತು.
ಆಯ್ತು, that is also to be rejected.
ಅದೇ ರಿಜೆಕ್ಟ್ ಆಗುತ್ತೆ.
ಆಮೇಲೆ
ದೆನ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಮತಗಟ್ಟೆ 249,977 ಮತಪತ್ರವನ್ನು ಈ ಹಿಂದೆ ಸಾರ್ವಜನಿಕ ಚುನಾವಣೆ ಮತ ಎಣಿಕೆಯಲ್ಲಿ ಅಂಗೀಕರಿಸಲಾಗಿದ್ದು, ಮರು ಎಣಿಕೆ
ಅಲ್ಲ, 5 ಜನಕ್ಕೆ ವೋಟ್ ಹಾಕ್ಬೇಕಾ? 5 ಜನಕ್ಕೆ ಹಾಕ್ಬೇಕಾ? 5 ಜನಕ್ಕೆ ವೋಟ್ ಹಾಕ್ಬೇಕಾ? ಹಂಗ ಕರೆಕ್ಟ್ ಆಗಿದೆ. 5 ಅಂದ್ರೆ
ಬಿದ್ದು ಇಷ್ಟು ಸುಮ್ಮನೆ ಹಾಕಿದ್ರಿ ಅನ್ನೋದನ್ನ ಹೇಳ್ಬೇಕು.
ಅಲ್ಲ, why vote is to be put to 5 candidates? 5 candidates were to be selected. Is it correct? 5 candidates were to be selected, is it?
I am not have the information immediately, my lord.
So 5 ಅಂತಂದ್ರೆ 5 ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಇದು that seal that is found on the top is not a marking made by this person. It is a marking that is coming from the back side. So therefore, yes. If the requirement is that every person is to select 5 candidates and 5 markings are made, then it is correct.
ಅದರಲ್ಲಿ ಹಲವು ಜನರಿಗೆ ಮತ ನೀಡಿದೆ ಅಂತ ತಿರಸ್ಕರಿಸಲಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಹೇಗೆ?
ಅದು ಏನಾಗಿದೆ, more than the requisite candidates, ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ ಒಂದು ಮಾರ್ಕಿಂಗ್ ಕಟ್ತಾ ಇತ್ತು.
ಅದೇ more than 5 ಬಂದಾಗ
ಇದು it is not a marking made by that person. It is a reflection of the seal that is put on the back side.
So one extra idan ಕಂಡಿದೆ ಅದು.
ಕಾಣಿಸುತ್ತದು, but it's not correct. Then it can be accepted.
ಅದು ಯಾರಿಗಾಗಿದೆ ಗೊತ್ತಾಗಿಲ್ಲ. ಇನ್ ಫೇವರ್ ಆಫ್
ಅದು ಕೊಡಿ ಇಲ್ಲಿ.
ರೆಸ್ಪಾಂಡೆಂಟ್.
ಅಲ್ಲ 5 ಅಂತಂದ್ರೆ
ಇವ್ರದ್ದು ಯಾವ್ದು ಗೊತ್ತಾ, ನಾಗರತ್ನ ಮತ್ತು ಇವ್ರದ್ರಲ್ಲಿ ಯಾರಿಗೆ ಅಂತ ಅದು ಅವ್ರಿಗೇನೆ ಇದೆ.
ನಿಮ್ದೆ ನಾಗರತ್ನ ನಂಜುಂಡೇಗೌಡ, ಇದು ನಿಮ್ದೇನೆ.
ಅದೇ ನಾಗರತ್ನನಿಗೆ ಬಂದಿದೆ.
ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಗೆ ಬಂದಿದೆ ಇದು.
ಸರಿ, ಅದನ್ನು ಅಂಗೀಕರಿಸಬಹುದು.
So this can be considered. All right. So this will be in your favor.
Number 3.
That is respondent.
Respondent in WP.
Respondent number
14.
Respondent number 14.
ಹೌದು.
ಆಯ್ತು. Next.
Then of course number 1 and 2 ನಲ್ಲಿ ಯಾರಿಗೆ ನಾನು ನೋಡಿಲ್ಲ.
ಇಲ್ಲ, ಅದು ಬರೋದಿಲ್ಲ because
ನಂಬರ್ 3 ಆಯ್ತು. ನಂಬರ್ 4 ಅಲ್ಲಿ ಮತಗಟ್ಟೆ 249ರಲ್ಲಿ ಮತಪತ್ರ 977 ಮತಪತ್ರವನ್ನು ಈ ಹಿಂದೆ ಸಾರ್ವತ್ರಿಕ ಚುನಾವಣೆಯ ಮತಗಟ್ಟೆ ಅಂಗೀಕರಿಸಲಾಗಿದ್ದು, ಮರು ಎಣಿಕೆಯಲ್ಲಿ ಸದರಿ ಮತಪತ್ರದಲ್ಲಿ ಹಲವರಿಗೆ ಮತ ನೀಡುವುದು ಕಂಡು ಬಂದಿರುವುದನ್ನ ಮಲ್ಟಿಪಲ್ ವೋಟಿಂಗ್ ಎಂದು ತಿಳಿಸಬಹುದು.
Please give that.
ಮಲ್ಟಿಪಲ್ ವೋಟ್ಸ್ ಅಲ್ಲ, 5ಗಿಂತ ಜಾಸ್ತಿ ಆದ್ರೆ ಮಲ್ಟಿಪಲ್.
ಇದನ್ ಮೇಲೆ ಮಾಡ್ಕೊಂಡೆ ತಗೊಂಡೋಗಿ 1 2 3 4 5 6 ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ತಿರಸ್ಕರಿಸಬಹುದು.
ಆದ್ರೆ ಇವರಿಗೆ ಯಾರಿಗೆ ಬಂದಿರೋ ಗೊತ್ತಿಲ್ಲ, ಪಿಟಿಷನರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ, no this has to be ರಿಜೆಕ್ಟೆಡ್
ಅಲ್ಲ, ರಿಜೆಕ್ಟೆಡ್ ಸರಿ. ಅದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂತ, ಯಾಕಂದ್ರೆ ಕೌಂಟಿಂಗ್ ಬಂದದ್ದು ಅದರ ವ್ಯತ್ಯಾಸ ಇರಬಹುದು ಅಂತ ನನ್ನ ಅಂದಾಜಿ.
ಇಲ್ಲ ಆಲ್ ದಿಸ್
ಇವರ ಅಲ್ಲ, ಈಗ ರಿಜೆಕ್ಟ್ ಮಾಡೋಣ, ಬಟ್ ಮೊದಲು ಡಿಫರೆನ್ಸ್ ಬರೋ ಕಾರಣ ಇರಬಹುದು ನಾನು ಹೇಳುತ್ತೆ. ಹಾಗೆ ಸವಿತಾ ಮತ್ತು ನಾಗರತ್ನಲ್ಲಿ ಯಾರಿಗೆ ಬಂದಿ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅದರಲ್ಲಿ.
This is not taken into consideration.
Yes, my lord. What I am saying is earlier it might have been in favor of petitioner or respondent ಅಂತ. ಯಾಕಂದ್ರೆ ಅಲ್ಲ, ಈಗ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಕ್ಕೆ ನಾನು ಕೇಳಿದೆ ಅದು ಯಾರ ಹೆಸರಿಗಿದೆ ಅಂತ ಹೇಳಿ. ನಾನು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಕ್ಕೆ ಸವಿತಾ ಅಂಡ್ ನಾಗರತ್ನ ಇವರು ಪಾರ್ಟೀಸ್.
ಅಲ್ಲ, earlier it was considered for Nagaratna only, your candidate.
ಅದೇ ಅದಕ್ಕಾಗಿ ನಮ್ಗೆ ಲೆಸ್ ಆಗಿರ್ಬೋದು ಈಗ.
Yes.
I understood that.
Yes.
No, what I am saying is ನನಗೆ I have not seen that. ಅದರ ನಾನು I just request your lordship to mention about what it is ಅಷ್ಟೇನೆ.
All right. Yes.
So that is ತಿರಸ್ಕರಿಸಬಹುದು. ನೆಕ್ಸ್ಟ್ ಐಟಮ್, ಮತಗಟ್ಟೆ 249ರಲ್ಲಿ ಪುನಃ 1139 ಮತಪತ್ರ ಹಿಂದೆ ಸಾರ್ವಜನಿಕ ಚುನಾವಣೆಯ ಮತ ಎಣಿಕೆಯಲ್ಲಿ ಅಂಗೀಕರಿಸಲಾಗಿದ್ದು, ಮರು ಎಣಿಕೆಯಲ್ಲಿ ಅನುಮಾನಾಸ್ಪದ ಎಂದು ಪರಿಗಣಿಸಿದಾಗ ಸದರಿ ಮತಪತ್ರದಲ್ಲಿ ಮತ ನೀಡಿರುವುದು ಸ್ಪಷ್ಟವಾಗಿರುವುದರಿಂದ ಮಾರ್ಕ್ ಇನ್ ಕಾಲಮ್ ಆಫ್ ಕ್ಯಾಂಡಿಡೇಟ್ 1 ಅಂಡ್ ಸ್ಮಡ್ಜ್ ಇನ್ ಎಲ್ಸ್ವೇರ್ ಅಂಗೀಕರಿಸಬಹುದು ಅಂತ ಹೇಳ್ತಾರೆ. ಅಂಗೀಕರಿಸಬಹುದು ತಾವು ನೋಡಿ. ಐ ಲೀವ್ ಟು ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಆಲ್ ದೀಸ್ ಆಸ್ಪೆಕ್ಟ್ಸ್. ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು, ಐ ಹ್ಯಾವ್ ನಾಟ್ ಸೀನ್ ದಟ್.
Sealing ಮೂಲಕ ಪ್ರಾರಂಭ ಕೈಯನ್ನು not their vote. Their vote is 1-1.
ಅಲ್ಲ, 5 ಜನರಿಗೆ ಹಾಕಿದಾರೋ, ಐ ಆಮ್ ನಾಟ್ ಏಬಲ್ ಟು ಸಿ ದಟ್.
ಇಲ್ಲ,
ತಾವು ಹೇಳಿದ್ರೆ ಸಾಕು.
No. It is given to ಇಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಮರಿಗೌಡ, ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಲಕ್ಷ್ಮಮ್ಮ, ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಸವಿತಾ. ಇಲ್ಲಿ ಏನಾಗಿದೆ, ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ ಒಂದು ಈ ಇಂಕ್ದು ಮಾರ್ಕ್ ಆಗಿದೆ ಮೇಲ್ಗಡೆ, ಅದಕ್ಕೆ ಸ್ಮಜ್ಡ್ ಅನ್ಬಿಟ್ಟು ಇಟ್ ವಾಸ್ ನಾಟ್ ಟೇಕನ್ ಇನ್ ಟು ಕನ್ಸಿಡರೇಷನ್. ಆಕ್ಚುಲಿ ಆ ಸೀಲ್ ಮಾಡಿರೋದಲ್ಲ, ಕೈಗೆ ಇಂಕ್ ತಗ್ಲಿರೋದು, ಅದು ಒಂದು ಮಾರ್ಕ್ ಆಗಿದೆ ಇಲ್ಲಿ.
ಸೊ ಡೌಟ್ಫುಲ್ ಅಂತ ಬಂತು.
ನೋ ಅದನ್ನ ಸ್ಮಜ್ಡ್ ಅನ್ಬಿಟ್ಟು ಅದನ್ನ ದೇ ಹ್ಯಾಡ್ ಕೆಪ್ಟ್ ಇಟ್ ಅಸೈಡ್. ನೌ ದೇ ಆರ್ ಸೇಯಿಂಗ್ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಟೇಕನ್ ಇನ್ ಟು ಕನ್ಸಿಡರೇಷನ್.
I leave it to your lordship about that.
Yes.
Next, ಇನ್ನೊಂದು ಐಟಮ್.
So this will be for the petitioner. Yes.
Then next number, ಮತಗಟ್ಟೆ 249ರಲ್ಲಿ ಪುನಃ 1268 ಮತಪತ್ರವನ್ನು ಈ ಹಿಂದೆ ಸಾರ್ವಜನಿಕ ಚುನಾವಣೆ ಮತ ಎಣಿಕೆಯಲ್ಲಿ ಅಂಗೀಕರಿಸಲಾಗಿದ್ದು, ಮರು ಎಣಿಕೆಯಲ್ಲಿ ಸದರಿ ಮತಪತ್ರದ ಹಲವರಿಗೆ ಮತ ನೀಡಿರುವುದು ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಮಲ್ಟಿಪಲ್ ವೋಟಿಂಗ್ ಅನ್ನು ತಿರಸ್ಕರಿಸಬಹುದು.
ಎಸ್ ಕೊಡಿ. ಇಲ್ಲ ರೀ, ದಿಸ್ ಕ್ಯಾನ್ ಬಿ ಅಕ್ಸೆಪ್ಟೆಡ್. ದಿಸ್ ಕ್ಯಾನ್ ಬಿ ಅಕ್ಸೆಪ್ಟೆಡ್. 2 ಅಲ್ಲಿ ಏನು ಕಾಣಿಸ್ತಾನೆ ಇಲ್ಲ. ನೋಡಿ ನೀವು ಹತ್ರ
It is in favor of my lord.
Yes, yes. 2 ಅಲ್ಲಿ absolutely nothing can be seen. This can be accepted in favor of R14. ತಗೊಂಡ್ರು ಕೂಡ you will have no difficulty. Yes, that will be accepted in your favor.
Very well, madam.
Yes.
So the first and number 1 and 2 are
1, 2 and 4. 1, 2 and 4
1, 2 and 4
are rejected.
Yes.
3 and 6 are in your favor.
Yes.
Only 1 is in favor of this petitioner.
Yes.
So ಅಷ್ಟು ತಗೊಂಡ್ರು ಕೂಡ
I get 585, she get 580.
yes, yes.
ಇದು ಏನು ಅವರು ಕೌಂಟ್ ಮಾಡಿದ್ದು, of course I don't want to find comment on their procedure. First they said petitioner is elected. I filed elected petition, that was set aside. Now in this writ petition, they said
The minister for counting or intended system to file it. They are filing after the day.
ನಾ ಹೇಳಿ ಬಿಟ್ಟು ಬಿಡ್ತೀನಿ. I am
Recounting application after the day, after 20 hours. It cannot be accepted upon. And before the Mysore court, they had almost evidences coming, then they said recounting after that has been challenged before this court. Recounting is not permissible after a day. Recounting only within minutes before announcing. Before the box is.
Anyway, see, there may be other grounds also raised in the election petition.
The main one, this one would be.
ಇರ್ಬೋದು. Now after recounting ಅಲ್ಲಿ ಇದು ಎಲೆಕ್ಷನ್ ಟ್ರೈಬ್ಯುನಲ್ ಮುಂದೆ recounting ಆಯ್ತಾ?
ಇಲ್ಲ recounting ಅಲ್ಲಿ ಆಗಿಲ್ಲ. I filed a petition in the chief judge court.
Within the counting period, they don't file the application. It should be in writing. They filed the writing application after a day. By the time these ballot papers were sealed and sent to this, it was not in the.
No, it's not like that, my lord. Your lordship kindly see, the counting was done up to 1 o'clock.
ಇಲ್ಲ, 1 ನಿಮಿಷ. In page number 102, there was a direction given calling for the ballot papers. Page number 102. Yes. Is it the final order, is it? No, it can't be the final order.
That is the mistake. It is the mistake. Final order put hence I called for ballot boxes. That's what they did. Earlier order, not 1 minute. They passed one order that was struck down and again another order. After announcing and uploaded in the internet, this order that was struck down and then fresh order was passed.
So what is the consideration?
Page one.
Where are the reasons found for allowing the petition?
Petition.
Paragraph number 43 ಅಲ್ಲಿ very next day 7 to 8 a.m. written objection was filed. It was denied. Suggestion that immediately after receiving complaint on 31/12/2020 at 5 a.m. an endorsement was given to the petitioner. Hence, at this stage, it is necessary to consider the defense taken by the respondents. They contended that it was indeed given on the same day.
No, oral, not in writing. Writing was given after writing.
My lord, may I make one submission, my lord?
Should give the.
Yes.
It was midnight. After midnight, it was counting was almost over. Then he objected. Then you said you give in the early morning writing. They gave an early morning writing. So that was considered by the trial court and said that there was no delay in filing the objection, but recounting was not done. So the court ordered get the ballot papers and order for recounting. That is order at page 102 or this end of the order saying that call for the ballot box, etc. That is the order.
But how could the tribunal allow the petition and then say call for the ballot papers?
Anyway, what has happened is that it is not allowing us such. It may be some error or erroneous way, but the order was
now substantial justice has been done. The recounting has been done in your presence, and all the rejected ballot papers are brought before this court. This court has verified the rejected ballot papers, and we have considered which can be allowed and which cannot be allowed, and we will proceed accordingly. All the contentions of both the parties have been considered now.
Now, one submission I want to make is this, my lord.
Yes.
First, they declared the petitioner as elected. Then, in the trial court, it was found that my objection was in time.
There was no recounting done.
No recounting done. No, recounting not done. But ballot paper. But here, your lordship, this court order, this honorable court.
We will accept your submission that recounting should have been done.
Yes. Now it is accomplished.
But the tribunal
now it is accomplished.
recounting.
I follow. It is accomplished. That's why I can't have a grievance. Is what your lordship observed. I can understand.
Yes.
But what I want to point out is 12/4/23. Your lordship, this court, this honorable court ordered for recounting. It was done on 23/5. In that, it was found equal. That was brought to your lordship notice, and they filed the report.
No, that is why we said
that is again wrong.
That is why we said the recounting should be done in your presence, and the entire thing has to be videographed.
That there the difficulty is this, my lord. Tahsildar was not done. Your lordship directed Tahsildar. That's all right. That's a procedural aspect. That's why I don't want to make much of it. What I am saying,
ultimately, it is done to the satisfaction of the parties in their presence.
Ali problem agide andre this report appears to be incorrect because Tahsildar was not there. Even the Tahsildar's report is he was not present antalla. Report annu odi nodi. Iga file madida report alli kuda what he says is he has not done anta. Your lordship directed him. But idu madidde yaru Tahsildar alla. It was done by the election officer and report is filed by Tahsildar. Tahsildar was not there. Tahsildar's presence agilla idu. Nodi adra report irode hage. The report is received from the ಚುನಾವಣಾ ಅಧಿಕಾರಿಗಳು ಇದರ ಪ್ರಕಾರ ಅಂತ ಹೇಳಿ ನೋಡಿ the report filed advocate ಜನರಿಗೆ ಅವರು ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದು ತಹಸೀಲ್ದಾರರು. But what was done is I got the report from the so and so ಅಂತ ಅವರು ಹಾಕಿದ ರಿಪೋರ್ಟ್ ಇದು. I don't know why he could not be present as per your lordship's direction.
He was present.
ಹಾಗೆ ಬರ್ದಿಲ್ಲ ಅವರು. In my present ಮಾಡಿದೆ ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ.
Allah sir, it is video recorded.
ನೋಡಿ ವಿಡಿಯೋ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ನೋಡಿ ಅವ್ರು ಬಂದಿದ್ರೆ ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂತ ನಮ್ಮವರ ಕಂಟೆನ್ಷನ್. ಸುಮ್ಮನೆ ಒಮ್ಮೆ ಬಂದ್ಬಿಟ್ಟು ಹೋದ್ರೆ ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Sir, let us not go on.
That's a procedural aspect. Whatever it is, I leave to your lordship at that. But what has happened is my client says that ಅವ್ರು ಬರ್ಲಿಲ್ಲ, ಇವರೆಲ್ಲ ಮಾಡ್ಕೊಂಡು ಏನೋ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ನನಗೆ ಹೇಳಿದ್ರು. ನಾನು ಅದನ್ನ ಹೇಳಕ್ ಆಗೋದಿಲ್ಲ ಆತರ. But it's an authority which has been directed by your lordship. He did not take it seriously. He asked somebody else to do it. That's all I want to point out.
Yes, Barkal. The petitioner. Was declared the returned candidate ಯಾವ ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ ನಿಂದು?
ದನಗಳ್ಳಿ.
ಡಿ ಸಾಲುಂಡಿ ಅಲ್ಲ, ಡಿ ಸಾಲುಂಡಿ ಟು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕ್ಷೇತ್ರದ ಚುನಾವಣೆಗಾಗಿ ರಿಟರ್ನಿಂಗ್ ಅಧಿಕಾರಿ ನಾನು ಸುವರ್ಣಸು ದಿನಾಂಕ ಸದರಿ ಚುನಾವಣಾ ಕ್ಷೇತ್ರದಿಂದ 26 ದನಗಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತಿಗೆ ಸದಸ್ಯನಾಗಿರಲು. ಸಾಲುಂಡಿ ಇಸ್ ದಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಯೆನ್ಸಿ. We'll continue at 2:30. It's already.
Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ಸರ್ ನಂದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ 37 ಮ್ಯಾಟರ್ ಇತ್ತು.
37 ಇನ್ನೂ ರೀಚ್ ಆಗಿಲ್ಲ ಸರ್, ಅದು ಆ ಮಧ್ಯಾಹ್ನ.
ಸರಿ ಸರ್.
ಮಧ್ಯಾಹ್ನ ರೀಚ್ ಆಗುತ್ತೆ.
ಅಪ್ಲಿಕೇಶನ್ ಮಾಡ್ತಾರೆ.
ಬರೋದಿಲ್ಲ ಮತ್ತೆ ಅವರೇ ತಗೊಂತಾರೆ. ಏನಿಲ್ಲ ಇದು ನಾಟ್
Someone asked her. I asked her to come and consult. Yeah.
ಅವಾಗಲೇ ಹೇಳಿದ್ ನನ್ಗೆ ಫೋನ್ ಕರೀತಿಲ್ಲ ಫೋನ್ ನಾನು ಫೋನ್ ಮಾಡೋಣ ಅಂದ್ರೆ ಇದಾಗಿದೆ ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ
ಎರಡೇ ನಿಮಿಷ ಕೆಲಸ ಬಂದ ಮೇಲೆ ಇಟ್ಟಿರ್ತೀವಿ ಎರಡೇ ನಿಮಿಷ. ಮೊದಲು ದಫೆ ಹಿಂದೆ ಗನ್ ಮ್ಯಾನಿಗೆ ಬರ್ತಾರೆ, ಒಂದ್ಸಲ ಬರ್ತಾರೆ, ಅವ್ನು ಕರ್ಕೊಂಬಪ್ಪಲ್ಲಿವರೆಗೆ ಇರ್ತಾರೆ, ಅವ್ನು ಒಳ ಬಪ್ಪಲ್ಲಿವರೆಗೆ ಒಳ ಬರ್ತಿಲ್ಲ, ಬರ್ತಿಲ್ಲ, ಬಪ್ಪೆ ಬರಲಾಗಳಿಲ್ಲ, ಕಡೆಗೆ ಬರ್ತಾರೆ. ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಬರ್ದಿದ್ದಾರೆ ಆ ಕಡೆ ಕೆಳಗಡೆ ಗೊತ್ತಾಗ್ತದೆ, ಸೈಡ್ ಅಲ್ಲಿದ್ದು ಯಾರೋ ಬಂದು ಯಾರೋ ಕೂತ್ಕೊಂಡ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ವರೆಗೆ ಹೋಗ್ತಾರೆ. ಚಲೋ ಕಷ್ಟ, ಚಲೋ ಕಷ್ಟ. ಒಂದು 2 ವರ್ಷಕ್ಕೆ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಮೇಲೆ 2 ವರ್ಷ, 1 ವರ್ಷ ಇಲ್ಲ ಬರೋದಿಲ್ಲ. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಜಾಯಿಂಟ್ ಪೇನ್ ಹೇಳಿದ್ನೆ. ಇಲ್ಲಪ್ಪ ಅದು ಎಲ್ಲಿ ತಾಗ್ತಿಲ್ಲ, ಅದೆರಡು ತಾಗ್ತಿಲ್ಲ. ಇಷ್ಟೊತ್ತು ಕೂತ್ಕೊಂಡು 2 ನಿಮಿಷ ಕೂತ್ಕೊ. ಹೆಚ್ಚಿಗೆ ಅಂತ ನೋಡ್ತಿಲ್ಲ, ಜಡ್ಜ್ಮೆಂಟ್ ಕೊನೆಯ ಲೈನ್ ಓದ್ಬಿಟ್ಟು ಅಷ್ಟೇ, ಅಲೋ ಮಾಡಿದ್ದ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದೆ. I'm appearing for the petitioner, my lord.
The repetition is allowed. The sale confirmation order dated 31/8/2004 at Annexure E, the order dated 16/3/2009 passed by the appellate authority at Annexure F, and order of the revisional authority dated 9/2/2011 at Annexure G are hereby quashed and set aside. The petitioner partnership firm is directed to be put back in possession of the scheduled properties. The second respondent bank is permitted to file a fresh application for execution of the award at Annexure A dated 10/4/2003 within a period of 2 months from the date of receipt of a certified copy of this order. If such application is filed, the recovery officer may proceed in accordance with law. The fifth respondent auction purchaser shall be entitled for return of the entire auction amount in terms of sub-rule 4 of Rule 38 of the Karnataka Cooperative Societies Rules, 1960 at the hands of the second respondent bank.
Continuation. Case number 2, case number 4, Ali Amarnathan.
For 14 minutes.
See that page number that you pointed out? 103. The petitioner who had contested for the membership of Thanagalli Gram Panchayat in the election held on 27/12/2020 was declared as the returned candidate from the constituency D. Salundi. Stop. -2. However, the declaration of results were challenged by respondent number 14 herein by filing an election petition in election case number 5 of 2021 before the 4th Additional Senior Civil Judge and JMFC, Mysore. So, have you furnished a copy of the election petition? Huh? 107. The election petitioner had sought to declare the election of the petitioner herein as member of the Gram Panchayat under general female category, as void. Semicolon. To declare the election petitioner as duly elected candidate of the Gram Panchayat of Danagalli Gram Panchayat under general female category, after getting the votes recounted. Stop. Learned counsel for the petitioner submits that in spite of there being a prayer made by the election petitioner that the tribunal may hold a recounting and thereafter declare the election petitioner as the elected candidate, nevertheless, the tribunal proceeded to pass the impugned order dated 15th of March 2023 while allowing the election petition and declaring that the election of the petitioner herein to Danagalli Gram Panchayat as void and further called for ballot box within a period of 1 month from the date of the order. Learned counsel for the petitioner would submit that the impugned order has been passed. Without even holding a recounting, and it is passed only on the ground that the election petitioner had made a written requisition for recounting, in accordance with law, and the returning officer had committed a mistake in rejecting such an application and not holding the recounting. Stop. It was further contended that there could not have been a void left by passing the impugned order declaring the election of the petitioner herein as void and not further declaring the election petitioner as the winning candidate, returned candidate. Full stop. Such a procedure adopted by the election tribunal is not in consonance with the provisions of the act and the rules. Full stop. Next para. Nevertheless, during the course of these proceedings, this court had directed the Tahsildar, Mysore Taluk, to do a recounting of the votes and forward the results to this court. Full stop. The said order was passed on 12/4/2023 and information was forwarded to this court that the petitioner herein and respondent number 14, both secured 584 votes each. Stop. Learned counsel for respondent number 14 had submitted that contrary to the information given to this court, it was declared that respondent number 14 had secured 1 vote more than the writ petitioner. Stop. Nevertheless, by an interim order dated 12/7/2023, this court directed all the contestants, including the writ petitioner and respondent number 14, to be present before the returning officer or Tahsildar on 17/7/2023 at 11 a.m. And a direction was also issued to the returning officer or Tahsildar to recount the votes in the presence of the candidates. It was also directed that the entire proceedings shall be video recorded. Full stop. Accordingly, the recounting was held, and a memo dated 24/7/2023 was filed by the learned AGA along with the communication bar report dated 20/7/2023 forwarded by the Tahsildar, Mysore Taluk. Stop. From the information provided by the Tahsildar, it is now found that the petitioner herein had secured 584 votes and respondent number 14 secured 580 votes. Full stop. 6 ballot papers were not counted, for various reasons. Full stop. All the 6 ballot papers which were not taken into consideration was forwarded by the Tahsildar through the learned AGA. Full stop. On going through the 6 ballot papers which were not counted by the Tahsildar, this court has found that 2 out of the 6 ballot papers are valid ballot papers, and therefore the same 3 valid ballot papers, and therefore they can be taken into account. We'll stop. Out of the 3, 2 votes are in favor of respondent number 14 and 1 in favor of the petitioner. We'll stop. Having regard to the factual finding, and since the recounting was held in the presence of all the contestants, including the petitioner as well as respondent number 14 and their respective counsels, the parties before the court cannot have any further grievance. We'll stop. As a consequence of the factual finding, this court finds that the petitioner has secured 585 votes and respondent number 14 has secured 582 votes. Stop. That being the position, comma, although there may be variation in the number of votes declared by the returning officer when what is found at present, comma, nevertheless, the end result would be that the petitioner has secured more votes than respondent number 14. Full stop. In that view of the matter, comma, this court, comma, having satisfied itself that the declaration of results made by the returning officer on 27/12/2020 comma, declaring the writ petitioner as the returned candidate from so and so constituency of Dhanagalli Gram Panchayat, comma, the said declaration of result has to be confirmed. Full stop. Next para. Consequently, the writ petition is allowed. Full stop. The impugned judgment dated 15th of March 2023 at Annexure A, passed by the 4th Additional Senior Civil Judge and JMHC, Mysore, is hereby quashed and set aside. Full stop. Ordered accordingly.
I think your lordship, but the date was wrong. Declaration is on 30/12, 27/12 last name. Date ನೋಡಿ ಅದು 30/12 ಇರಬೇಕು, not 27/12. Declaration.
ಯಾವ ಡೇಟ್ ಹೇಳ್ತಾ ಇದ್ರ ನೀವು?
ಅವರ ಡಿಕ್ಲರೇಷನ್ ದಟ್ he selected ಅಂತ ಹೇಳಿದೆಲ್ಲ, ಪೇಜ್ 103 ನೋಡಿ, ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಕೂಡ ಹಾಕಿದ್ದಾರೆ. ಇಟ್ ಇಸ್ ಡೇಟೆಡ್ 30/12 ಅಂತ ಇದೆ, Annexure C. 30/12 ಇರಬೇಕು. ನನಗೆ 27 ಅಂತ ಕೇಳಿತ್ತು.
ಯಾವ ರೀಕೌಂಟಿಂಗ್? 30/12. The declaration was made on 30/12. ಹಂಗಾದ್ರೆ ಅದು 27 ಅಲ್ಲ, 30/12
ಅಷ್ಟೇನೆ.
Yes.
Correction ಇರಲಿ ಅಂತ just I inform.
Yes.
Sorry, I gave a lot of trouble to your lordship.
ಇಲ್ಲ.
Recounting.
Trouble ಏನಿದೆ? These are all. This is what we are doing here day in and day out. Yes.
ಅಲ್ಲ, ರೀಕೌಂಟ್ ಗೆ ತಮ್ಮ ಹತ್ರ ಮಾಡ್ಸಕ್ಕೆ ಮಾಡಿದೆ.
Yes. ಏನು arising out of election petition? This matter after service of notice on response number 1 to 11. Interim order granted earlier stands extended till the next date of hearing.
Covers the point.
ಯಾವ ವಿಚಾರ ಹೇಳಿ?
Because the election petition has been rejected, my lords, as not maintainable. He's stating that on furnishing of details of pending criminal proceedings in the affidavit would not come under the corrupt practices under the panchayat.
They were referring to some Supreme Court.
The election commission referred to this, right? That covers that point.
Which one?
That's the non-furnishing of details regarding criminal proceedings has been held to be a corrupt practice by the Supreme Court.
ಏನ? You filed the election petition and filed an application seeking dismissal of the election petition as not maintainable.
Non-furnishing of pending criminal proceedings does not amount to corrupt practice is what the contention of the correspondent was. That has been accepted wrongly by the election petition. Whereas the Supreme Court has referred to by the election commission last occasion, the case of.
So that judgment which was cited by the learned counsel is in your favor.
Yes, as very specifically stated that in all cases of elections where even non-furnishing of entire details also has been said to be a corrupt practice, not just non-furnishing at all. Here is a case where they don't furnish the details at all. They rather state that there are no pending criminal proceedings in the affidavit.
Who is the contesting respondent?
First respondent.
Mr. Sunkapur. You are Mr. Sunkapur. You are the learned counsel. On record. You know? You want to appear? There is no difficulty. Yes, it's a position of law declared by the Honorable Supreme Court. So the election petition should go on. That's all. Nothing. What else will happen? Nothing will happen. The dismissal of the election petition, accepting your application, was not correct. Adalla bere. That is not the ground. That is not the ground on which the election petition was dismissed. The election petition was dismissed on your application, where you had stated that what was your application? Where is it? Page number.
Page 135 is there.
135.
Is there.
Yes. All that will be considered, sir.
Yes.
In the election petition, all that will be considered. The matter has to be restored. Yes. Which is that judgment? Learned Counsel. The Arvind H. has filed NOC Wakalat on behalf of respondent number 1. Full stop. Therefore, the name of Learned Counsel Sri G.J. Sunkapur, who had filed a KVA petition on behalf of respondent number 1, will be removed from the cause list. Full stop. Yes. The petitioner who had filed an election petition in election case number 1 of 2022 before the senior civil judge, itinerary court, at Jagalur, is aggrieved of the impugned order dated 8/9/2022 passed by the election tribunal dismissing the election petition holding that no grounds are made out for declaring the election of respondent number 1 as null and void. Let's go. Learned Counsel for the petitioner submits that respondent number 1 herein filed an application in IA number 5 in the election petition under section 19 of the Karnataka Gram Swaraj and Panchayat Raj Act, 1993, read with section 151 of the Code of Civil Procedure, seeking dismissal of the election petition as not maintainable. So, Learned Counsel submits where is your election petition?
Page 25. Next to the P.
Where are the grounds?
Para number 6 is okay. Page 27.
ಅಷ್ಟೇ ಒಂದೇ ಗ್ರೌಂಡ್ only ground. That is the only ground. What is this about the
PIN number.
PIN number? Huh?
In regarding commercial tax.
Hmm.
The PIN number which has been given as based on that, they have not clear all the use is the other account which has been mentioned. But the main one here would be that the one is publishing of details of criminal proceedings is the main ground. We also submitted the charge sheet.
Submits that there are at least two grounds raised in the election petition, namely that the first respondent herein did not disclose a criminal case registered against him in special bracketally Lokayukta close case number 6 of 2016. Which was pending consideration before the district court at Davangere. Stop. It was also contended that the first respondent who had a commercial establishment and having TIN number 2917065947 was alleged to have been a defaulter in payment of taxes, commercial taxes. Stop. The learned counsel would therefore submit that the election petition could not have been dismissed on the ground of maintainability, since it could not have been contended at the hands of respondent number 1 that the election petition itself is not maintainable. Full stop. There is no reasons forthcoming from the impugned order as to why the election petition is not maintainable in accordance with law. Stop. On the other hand, while considering the application, interlocutory application filed at the hands of respondent number 1, the election tribunal seems to have gone into the merits of the matter without permitting the parties to adduce evidence. Stop. Even otherwise, it is submitted that the opinion of the election tribunal that the allegation made by the petitioner in the election petition regarding non-disclosure of the criminal case along with the nomination papers filed by a candidate does not amount to a correct practice, comma, is contrary to the opinion of the Honorable Supreme Court. Stop. In this regard, learned counsel draws the attention of this court to a decision of the apex court in the case of Krishnamurthy versus Sivakumar and others, bracketed in 2015, close 3 SCC 467, wherein it was held that non-disclosure of criminal antecedents of candidate in entirety and in full detail, comma, especially pertaining to serious crimes or those relating to corruption or moral turpitude, creates impediment in free exercise of electoral rights, comma, hence constitutes corrupt practice of undue influence. Stop. Nevertheless, comma, the learned counsel would submit that the dismissal of the election petition at an interim stage on an interlocutory application filed at the hands of respondent number 1 cannot be sustained. Stop. The learned counsel would therefore submit that the matter has to be considered by the election tribunal in accordance with law. Full stop. Next para. In view of the judgment cited by the learned counsel for the petitioner, comma, learned counsel for respondent number 1 submits that matter may be remitted back to the election tribunal so that opportunity of hearing will be afforded not only to the writ petitioner but also to the first respondent hearing. Stop. The learned counsel would also submit that the observations made by this court in this writ petition regarding the question as to whether non-disclosure of the criminal antecedents of the first respondent would amount to correct practice or not should be kept open. Full stop. Next para. Accepting the submission of the learned counsel for respondent number 1. All questions will be left open. Comma, the writ petition is allowed. Full stop. The impugned order dated 8th of September 2022 at Annexure J, passed by the senior civil judge, comma, itinerary court, comma, at Jagaluru, is hereby quashed and set aside. Full stop. The matter stands remitted back to the learned senior civil judge, comma, itinerary court, comma, at Jagaluru for reconsideration in accordance with law. Stop. The proceedings shall recommence from the stage where before taking up the IA number 5, which was filed at the hands of respondent number 1 hearing. Stop. Needless to mention that all contentions are left open. Stop. Having regard to the fact that the elections were held on
13/12/2020.
13
12/2020.
12/2020, comma, the election tribunal shall expedite the proceedings and conclude the same as expeditiously as possible and at any rate within a period of 4 months from the date of receipt of a copy of this order. Stop. 4 months. Stop. The parties herein are directed to appear before the learned senior civil judge, itinerary court at Jagaluru on 7th of August 2023, without waiting for further notice. Stop. 4 months from 7th of August. Yes. ಹೇಳಿದ್ನಲ್ಲ, I have said so.
Number 2, number 1. This number 2.
ಹಂಗಾದ್ರೆ ಬೇಡ ತೆಗೆದ್ಬಿಡಿ. Yes. ತಗೊಳ್ಳಿ ಫೋಟೋ. ಯಾವ ಗ್ರಾಮ ಪಂಚಾಯತ್? ಆನೂರು. DCA woman and general. ST. There are 32 gram panchayats. SC 9. ST, you are asking for ST. Huh? ಏನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಓದ್ತಾ ಇದ್ದೀರಾ? You are not concerned with that. Yes. So 4 ಇರೋದ್ರಿಂದ, see, there are only 4 posts of scheduled tribes. There are 32 gram panchayats. Cycle has to go on. ನಿಮಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ 2010 ಫಸ್ಟ್ ಟರ್ಮ್ ಅಲ್ಲಿ ಬಂದಿದೆ ಆಯ್ತಾ. ಇಫ್ 4 posts are to be rotated, 8 terms ಆಗುತ್ತೆ. 8 4s are 32. ಸೊ 8 terms ಆಗ್ಬೇಕು. ಇವಾಗ ನಿಮ್ಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ 2010 ಫಸ್ಟ್ ಟರ್ಮ್ ಅಲ್ಲಿ ಬಂದಿದೆ. ಅದಾದ್ಮೇಲೆ 1 2 3 ಆಗಿದೆ. ಇವಾಗ 4ನೇ ಟರ್ಮ್. There cannot be a repetition of scheduled tribe to you. You will have to wait for 8 terms. Okay. The petitioner who is a member of Anur Gram Panchayat of Chintamani Taluk is aggrieved of the impugned notification issued by the fourth respondent, Deputy Commissioner, election officer. Stop. It is the contention of the petitioner that scheduled tribe reservation to the post of Adhyaksha was last given to the Gram Panchayat during the year 2010, bracket first term. And therefore, reservation of scheduled tribe should have been given to the Gram Panchayat this time. Full stop. Next para. Learned Additional Advocate General submits that there are 32 Gram Panchayats in the Taluk, out of which 9 posts of the Adhyaksha are reserved for scheduled castes, 4 for scheduled tribes, 2 for BCM-A, 1 for BCM-B, and the remaining 16 are general category seats. Full stop. That being the position, since there are only 4 posts of scheduled tribes in the Taluk, and there being 32 Gram Panchayats, if a cycle has to complete in the Taluk, it will take minimum of 8 terms. Stop. Learned AAG submits that since admittedly scheduled tribe reservation was given to the Gram Panchayat in the year 2010, and thereafter this is the 4th term of elections, the petitioner cannot expect scheduled tribe reservation to the post of Adhyaksha. Stop. Next para. Moreover, a GPVP talking. GPPVP. Next para. On hearing the learned counsel for petitioner, the learned AAG, and on perusing the petition papers, this court finds that the respondent deputy commissioner has followed the guidelines. Full stop. As rightly submitted by the learned AAG, repetition of a reserved category is permissible only after completing of a cycle in the Taluk. Full stop. That being the position, and in view of the fact that ST scheduled tribe reservation was given to Anur Gram Panchayat during the year 2010, and the next expected repetition can only be after 8 terms, the contention of the petitioner cannot be accepted. Full stop. Next para. Consequently, the writ petition stands dismissed.
One matter, this number 1, serial number 15.
ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಹೇಳಿದ್ನಲ್ಲ, ಡಿಕ್ಟೇಟೆಡ್ ಪೋರ್ಷನ್ ಇದೆ ಅದರಲ್ಲಿ. ಲರ್ನಡ್ ಅದು ಹಾಕೊಂಬಿಡಿ.
Number 15, Kalyana.
And 5 statements.
Who approached the executive officer?
The respondent.
Hmm.
But in the order, we want to give order. Is the record that the petitioner has not been filed a statement about it. That is what record is the order. Page number 12.
Hmm.
Now they don't need last one. The last one thing the sixth paragraph. Other than the Undanipur in answer in there. The motive of the Acharaki, Wakala solicits. ಒಟ್ಟು ಕುಟುಂಬದ ಆಸ್ತಿಗಳ ವಿಭಾಗ ಪಂಚಾಯತ್ ಸಂರಕ್ಷಣಾ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಪೂರ್ವ ಅವಧಿಯಲ್ಲಿ ಒಂದನೇ ಪ್ರತಿವಾರಿ ಈ ಮೇಲ್ಕಂಡ ದಾಖಲೆಗಳು ಪ್ರಕರಣದ ವಾದ ಪತ್ರಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಯಾವ ಆಧಾರದ ಮೇಲೆ ಅವರ ಹೆಸರಿಗೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ದಾಖಲೆಗಳು ನಮೂದಿಸುತ್ತಿದ್ದಾರೆ. ಪ್ರಕರಣ ಎರಡನೇ ಪ್ರತಿವಾದಿ ಯಾವುದೇ ಮಾಹಿತಿ ಪರಿಶೀಲಿಸಬೇಕು. ಒಂದನೇ ಪ್ರತಿವಾದಿ ಮೇಲ್ಮಂಡಲವರ ಶೀರ್ಷಿಕೆಗಳು ತನ್ನ ಹೆಸರಿಗೆ ದಾಖಲೆ ಮಾಡಿಸಿಕೊಂಡಿರುವ ದಾಖಲೆಗಳ ಪ್ರಕರಣದ ಗಂಭೀರತೆ ಈ ಕೆಳಗಡೆ
When was the Qatar registered in your name?
It was registered from 84-85. Qatar stands in the name of Reservation. There's 5 statements of objections.
Huh?
Page number 21. Statement of objections 5 pages. Contention of the respondent number 5. He was not residing in the he is not residing in the village. It was given to the custody of the petitioner.
Who has filed this suit?
The petitioner filed his objection to number 21.
Allah suit.
Suit filed by the petitioner. That is suit for bearing judgment. That's pending for consideration before the suit.
This you filed after the appeal was filed before the executive officer? It appears so. Either after the impugned order is passed. So that may not be of much help. Yeah, 2023.
22 is the order. Subsequent.
January 2023. Yes.
Without even considering the objection.
Where is your objection?
Page number 21.
21. 21.
Yeah, annexure C.
ಏನು ಇಲ್ಲ ಡೀಟೇಲ್ಸ್ ಇದ್ರಲ್ಲಿ.
The petitioner is not in possession and enjoyment of the property. He was not residing in the address as stated since some years.
No, what are you saying about how did you?
That's what I said. Since some years, the respondent is in possession. That is the petitioner here.
It's not about possession, sir. How are you in possession? What is your legitimate right?
I was in possession of the property based on my possessory rights. After conducting measure, I was getting it.
So you don't have anything to say about your title.
Title they have not said indeed. But however, to this Islam that I continue to be in possession, that has been accumulated by the respondent number 5. I'm in possession of the property.
How did you, sir? How did you come in possession? If you are not able to say anything.
The respondent number 5 admittedly is not residing in the village. He is residing in Bangalore.
Irbodu, sir.
And the petitioner has been in possession. So in the public memorandum, page number 14. Is now residing. Page number 14.
Sir, we are not concerned about the possession of the property. We are only concerned as to how your name got entered in the Qatar register, and if you find that illegally without affording an opportunity of hearing to you, it was removed, then we can interfere. Otherwise, no. Huh?
Kindly page number 14. Not directly related on the but the memorandum.
Son of late Chicken Narasimha. Oh, small change. So if you are not able to say anything regarding your title, then it is difficult. ಅದನ್ನೇ ಏನಿದ್ರು ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ ತರ ಬೇಕಾದ್ರೂ ಆರ್ಗ್ಯೂ ಮಾಡಬಹುದು. We are only concerned with the Khata. How your name came to be entered in the Khata register is the question.
Regarding the relationship with the party.
Learned HCDP takes notice for respondent number 1. क्या तगता है इधो शेड्यूल गट्टा हाँ learned counsel Sri MS Devraj, who is present in the court, takes notice for response number 2 to 4. Issue emergent notice to respond number 5. Learned counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on learned counsel for response number 2 to 4 and a copy on the learned HCD.
Taking undue advantage of order forms, the respondent should not dispose the
Baradilla, we are not concerned with possession at all. We are not concerned. Anyway, you have filed a suit. Obtain an order.
Final disposal. Giving Narasimhan.
ಏನಾಯ್ತು Yes. In spite of several opportunities being given at the request made by the learned counsel for the respondent institution, there has been no settlement between the parties. Full stop. The learned counsels are required to go on with the matter on merits. Full stop. Next para. Released from parted.
Number 33. Understood.
Huh? You are appearing for? Huh? Who is fourth respondent? Huh? Anyway, you file statement of objection. Please file statement of objections. Please file statement of objection. 2 weeks time is granted to the respondents to file statement of objections. Yes. For withdrawal. Am I there? Not really. ಯಾವುದು ಅವರು ಕೊಲಿಗ್ ಇದಾರಲ್ಲ ಸೋಮವಾರ ಇಡೇ ಅವರ ಕೊಲಿಗ್ ಆ ಮ್ಯಾಟರ್ ಬರ್ತಾ ಇದ್ದಲ್ರಿ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಕ್ರಿಮಿನಲ್ ಸೋಮರೆಡ್ಡಿ ಅಂತಾನೆ ಬರ್ತಾ ಇದ್ದಾರೆ. ಆಫೀಸ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಶೋ ದಿ ನೇಮ್ ಆಫ್ ಲರ್ನಡ್ ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಸೋಮರೆಡ್ಡಿ ಏನೋ ಇದೆ ನೋಡ್ಬಿಟ್ಟು ಹಾಕಿ ಸಿನ್ಸ್ ವೆಂಕಟೇಶ್ ಸೋಮರೆಡ್ಡಿ for the petitioner, comma while removing the name of learned senior counsel Sri P.P. Hegde from the cause list. Stop. Release this matter on 9th of August. Huh? Instead of giving sex, that man, they are to not favor the respondent in the third color. Notes will not shall taken in my petition. Nothing to do with this religion section and the boundary has also been changed. They have not taken the data from the service departments. They have relied on some correct somewhere. Whereas detected that has been thrown into the service. Nothing to do with this case. The first instance, there are two people violated the directions of the circular government. Yeah, this one of the cities will not it's property and they go nothing to this case. Legal society is from the Allah sir, who approached the authority seeking Site number 6061 and release this. Allah, who formed the layout? Sixth respondent formed the layout.
My lord, this just site is not in this of 6162 section number is belong to the petition. They say not
Two sites.
Two sides. Two sides.
Huh.
Two sides. See, there are a lot of release the sites. What happened? My lord, we have released the 60% sites. Remaining 40% we are on because we are level is not our. That is the reason, my lord, I will have given a entire development now. And also meanwhile, my lord, petitioners by the suit against him to respond. Your time is in.
A sale deed is executed in your favor. Where are the sale deeds? Manager J is the Tiddupadi Patra.
Before approval, my lord, is the property from the.
The why are you approaching the planning authority then? If you have purchased the property much before the landowner got the approval from the authority, why should you go before the planning authority now? About what?
Because the sites are in that area, good area.
So your grievance can only be against respondent number 6. It cannot be against the planning authority. Where is the question of releasing, sir? Sir, you have nothing to do with the planning authority. Sale deed was executed in your favor way back in the year 1999. So therefore, your grievance is against the 6th respondent. How can it be against the planning authority? Sir. No. Please, no. See, they have certain norms which are required to be fulfilled by the applicant. The applicant, who is a developer, who makes an application to the authority, says, I want to develop this area into a residential layout or whatever layout. Please give me the approval. They will impose certain conditions and permit the formation of the layout. But they will say, after completion of the formation of the layout, the applicant has to once again approach the authority seeking release of the sites that can be disposed of. Avaga, they will come and inspect. They will find out whether the layout has been developed. If it is not developed, if it is developed only to a partial extent, then they will release only partially. After completion of the formation of the entire layout, the balance sites are released. How can you approach the authority asking them to release your sites? Madak baradilla. No. Please understand. If they have already released certain sites, please show which are the sites that they have been released. Page number 61, annexure L.
That is against the consideration of the government. Government they should have brought in or the village sites in that manner. And it be done. I would have definitely bought in the 60% of the sites. In the first instance itself. There they have completed. Or else. All the states, except all the states are on one side. Except the area is being there.
ಅದೇನ್ರಿ ಅನಿಯತ ಅಂತ ಹೇಳಿದ್ರೆ ಇಟ್ ಇಸ್ 6061 is clearly ಅಲ್ಲಲ್ಲ ನೀವು ಯು ಸೆಡ್ ಅನಿಯತ ನಿವೇಶನಗಳು ಅಂತ ಬರ್ದಿದ್ರಲ್ಲ, ಹೌ ಡು ಯು ಸೇ ಇಟ್ ಇಸ್ ಆಡ್ ಸೈಟ್? ಆಯ್ತು. Which is the document by which you have released the sites? Allah, you also not produced a copy of the order passed by the planning authority by which they have released the sites. Yav sites release ಮಾಡಿದ್ದಾರೆ? Yav sites release ಮಾಡಿದ್ದಾರೆ? And why have you not taken action against the sixth respondent? Atalla, you know there is a provision under the Town and Country Planning Act. Already layout was approved yavaga even before 2007. But yen ಮಾಡ್ತಾ ಇದೀರಾ for so many years now? ಇದು ಕೊಡ್ರಿ ಟೌನ್ ಅಂಡ್ ಕಂಟ್ರಿ ಪ್ಲಾನಿಂಗ್ ಹಾಕ್ಬಿಟ್ಟು. If any person does any work in contravention of subsection 1 or in contravention of the modifications and conditions of the sanction granted under subsection 2 or despite refusal for the sanction under the said, may direct such person by notice in writing to stop. Adalla there is a provision which says if it does not complete the formation of the layout, you are entitled to take over and form the layout. You can recover the charges from the sixth respondent. There is a provision. Why are you not doing that? It is there. It is there. Circular already provision is there. Please wait. I have dealt with one case like that. In respect of BDA. There is a provision. I will point out. Adala. See, if a developer does not complete the development activity, it will be the responsibility of the town planning authority to take over. Huh? 17(2)(c). Adala. There is a clear provision. Huh? Clause 4. Huh? Four. 2C.
Development works are not completed within the specified under the project module to the planning approach shall be forwarded to planning.
I am not getting that. This book also. ಇದೆಲ್ಲ ಈ ತರ ಮಾಡ್ತಾರೆ. There is one more provision where it states that if he is not able to complete, then the planning authority will take over. It has to complete, recover the expenses from the developer. Circular Allah. There is a provision itself. There is a provision. Which provision? Circular Allah, sir. There is a provision, sir. I remember that learned counsel, Mr. Nitin, who was the additional advocate general. He had argued this matter. There is a provision. Huh? Illa. Town and Country Planning Act. That was a matter arising out of the Bangalore Development Authority. Nitin Mahesh, ಏನು ಅವರ ಹೆಸರು? ಹೌದು. You will have to point out all that provision, sir. You will have to point out that provision and seek a direction to the planning authority. If they say it is not complete, then let them complete and recover the money from the developer. The what you know? Correct. That is in fact in consonance with the provision. I have read the provision, it is there. You will have to point out to the provision and this circular of the government. Then we will issue direction to the planning authority to go ahead, complete the formation of the layout. And since he has already executed sale deeds in their favor, there is nothing more you can recover from them. You have to recover from the developer. But they cannot be kept like this perennially waiting for Allah nimdu tappide. Angalla, adalla. Even before the approval is given, you have gone and you have purchased the site.
In that case, they should have brought me in as a different holder. They should not have included my area in the.
How should they know? How should they know about that? Adalla baradilla. You have only a grievance against the sixth respondent. In that case, no.
He's approving the layout. They should see the ground and you are there. They have delayed us.
Sir,
they have done it. They have not followed the data from the survey department. Government is maintaining. That is not followed. Because of these.
ನೀವು ಸೈಟ್ ಪರ್ಚೇಸ್ ಮಾಡುವಾಗ ಮಾಡಕ್ ಮುಂಚೆ ಇದು ಅಪ್ರೂವ್ಡ್ ಲೇಔಟ್ ಏನು ಅಂತ ನೋಡ್ಕೊಂತಾನೆ ಪರ್ಚೇಸ್ ಮಾಡೋದು ಮತ್ತೆ ಹಂಗ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್. ಹಂಗಲ್ಲ ಡಿಲೀಟ್ ಮಾಡಕ್ಕೆಲ್ಲ ಬರೋದಿಲ್ಲ. Learned counsel for the petitioner is required to point out to the provision of law contained in the Karnataka Town and Country Planning Act, which mandates that the planning authority which approved the layout shall complete the formation of the layout, if the developer abandons the development work. Stop. The planning authority is empowered to collect the sum incurred for the expenses in terms of the said provision. Full stop. Next para. The learned counsel for the petitioner has also pointed out to a circular issued by the state government, by the urban development department of the state government in this regard. Full stop. Next para. Release this matter on 2nd of August. Day after tomorrow. On 28th of July. Right. Thirty. Learned counsel Sri Venkatesh Somareddy, appearing on behalf of learned senior counsel Sri P.P. Hegde, who was earlier on record for the petitioner, has filed a memo dated 26/7/2023 stating that since the petitioner is now a member of the Gram Panchayat, the prayer in the writ petition has become infructuous. Full stop. Therefore, it is prayed that the petitioner may be permitted to withdraw the writ petition. Full stop. Next para. The memo is taken on record subject to all just exceptions. Accordingly, the writ petition stands disposed of as the prayer made in the writ petition has become infructuous. Statement of objections. Please file it in the office. Please serve a copy on the other side. Learned counsel for respondent number 3 submits that the statement of objections are ready and a copy is served on the learned counsel for petitioner. Full stop. Learned counsel may file the objections in the office. List this matter on 2nd of August.
It's from 1 year suspension.
No, it will come up. Next week it will come up.
Since then, I have not been paid such state allowance.
We do not know. The matter itself may be disposed of. We'll see. Let us see. Yes. No.
37.
Lord, I represent Lord the petitioner. Lord, the 27 petitioners are Lord in the street. Lord, as that Lord, though there is an order passed by the Honorable Court, the shops were locked and they are not permitted, Lord, to run the business, Lord. Lord, earlier, Lord, the eviction notice was issued by the municipality against Lord the petitioner. Lord, that notice, eviction notice was challenged before this Honorable Court in the writ petition. This Honorable Court granted an interim order that we should not be dispossessed. And Lord, ultimately, writ petition came to be allowed. But the direction is, it was held that the notice issued, eviction notice should be treated as only a notice, not an order of eviction. And ultimately, Lord, the authorities were directed to Lord consider our representation by way of objection, showcasing the notice, and to pass some order. And as on this day, Lord, we filed our objection, and they have not taken any decision, but they have locked the shops. They have locked the shop, and we could not run the business. And there is no Lord order passed against us, Lord, as on this day for eviction.
You want an order of eviction to be passed against you under the Karnataka Public Premises Act.
That was the finding, Lord, before this.
No difficulty. We will direct them to take action only in accordance with law, but we will also direct them to blacklist all of you, and you will not get the shops any further in future.
No, my lord, my request.
If you are agreeable for that, I will pass orders and I'll direct them to take action only in accordance with law. But they will blacklist you and you will never get the shops again.
No, I'm not. That is not, Lord. Lord, my request is allow us to run the shop.
Okay, no difficulty. I'll pass that order, but I'll also tell that you will be blacklisted and
whatever.
Shops again. Barkali.
No, my request, Lord. Lord, I'm sorry, Lord. I'm not, Lord.
Yes.
If the Lord such blacklist is made, Lord, certainly, Lord, they will be thrown to street.
ಕಾನೂನು ಬೆಲೆ ಇಲ್ವಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ, ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವರು ನೋಟಿಸ್ ಕೊಟ್ರು, ಎವಿಕ್ಷನ್ ನೋಟಿಸ್ ಡೈರೆಕ್ಟ್.
You want them to follow the law and evict you?
ಇಲ್ಲ, ನಾನು ಅಷ್ಟು ಹಾರ್ಷಾಗಿ ನಾವಿಲ್ಲ, ಅಷ್ಟು ಹಾರ್ಷಾಗಿ ನಾವಿಲ್ಲ. ನಾವು ರಿಕ್ವೆಸ್ಟ್ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ?
Shops are being put for auction. Participate in the auction.
ಅದು ಪರ್ಮಿಷನ್ ಕೊಡ್ತಾ ಇಲ್ಲ ಅವ್ರು, ನನಗೆ ಪರ್ಮಿಷನ್ ಕೊಡ್ತಾ ಇಲ್ಲ. ಆಕ್ಷನ್ ಮಾಡಿದರೆ ಯಾರು ಬಿಡ್ಡರೇ ಇಲ್ಲ ಅಲ್ಲಿ. ಈಗ ನಮ್ಮನ್ನ ಬಿಟ್ಟು ಆಕ್ಷನ್ ಮಾಡಿದ್ರು, ಅಲ್ಲಿ ಬಿಡ್ಡರೇ ಯಾರು ಬರ್ಲಿಲ್ಲ. ಈಗ ಅವ್ರ ಏನಾರು ಆಕ್ಷನ್ ಮಾಡಿದ್ರೆ ನಮ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ತಾವು ಪರ್ಮಿಷನ್ ಕೊಡಿ, ನಾನು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡ್ತೀನಿ.
Yes.
The previous case issue was the auction was perfect. Few of the petitioners participated and few of them not participated, and few of the legal agents participated. So accordingly, successful bidders were awarded the subsidy. That was challenged, and that was again said we have to make a fresh application.
ಇವಾಗ ಫ್ರೆಶ್ ಆಗಿ ಆಕ್ಷನ್ ಕಂಡಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Otherwise, see, you'll only be struggling like this. You'll have to take action in accordance with law. We do not know how long that is going to take. Barkali. I have passed such orders in another writ petition.
ಇಲ್ಲ, ನಾವು ದಯವಿಟ್ಟು ಅಷ್ಟು ನಮಗೆ ಎಲ್ಲ ಲೈವ್ಲಿಹುಡ್ ಸ್ಮಾಲ್ ಪೆಟಿ ಬಿಸ್ನೆಸ್.
ಅದಕ್ಕೆ ನೋಡಿ, ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. The law requires that the best price has to be given to the municipality.
I will avoid with that. I will avoid that.
Therefore, participate in the auction, bid for it, take it.
Please,
you will get the extension for another 5 years.
ಇಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ನಾವು ತಯಾರಿದೀವಿ. ಅಲ್ಲಿ ಸ್ವಲ್ಪ ರಾಜಕೀಯ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ.
ಅವೆಲ್ಲ ಇಲ್ಲ, ಪಬ್ಲಿಕ್ ಆಕ್ಷನ್.
Please
participate and you take it.
Please, till then, Lord, everything is, Lord, arranged. We may be permitted to run the business. Our goods are inside, and
the contention of the petitioners is that they have been in occupation of the shops belonging to the third respondent, City Municipal Council, Hunsur, for more than 25 years now. And the municipality should not dispossess the petitioners without following due process of law. Stop. Learned counsel for the petitioner would, however, submit that if an opportunity is given to the petitioners to participate in the auction, and the petitioners will be able to bid for the shops, which will be not only for the benefit of the petitioners but also for the municipality. Full stop. However, such opportunity is being denied to the petitioners. Full stop. Next para. Learned counsel for the third respondent, CMC, Hunsur, is hereby directed to secure instructions from the municipality as to whether the shops can be put for auction, and if so, the dispute can be resolved. Stop. Next para. To a suggestion made by this court that if the petitioners insist that they have to be evicted only in a manner known to law by following the provisions contained under the Karnataka Public Premises bracketally Eviction of Unauthorized Occupants Clause Act, comma, then no doubt the municipality shall be directed to evict the petitioners only in accordance with law, comma, however, comma, there shall also be a direction to the municipality to blacklist the petitioners if they insist that they have to be evicted only in accordance with law.
Lord, I am not insisting for that. Lord.
To this, the learned counsel for the petitioner has submitted that the petitioners are not standing on the said position that they should be evicted only by following the provisions contained in the Public Premises Eviction Act. Full stop. Their request is that they should be permitted to participate in the auction. ಇದನ್ನ ಮುಂಚೆನೆ ಬರ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಇದನ್ನ ಹಾಕೊಳ್ಳಿ. Next para. Release this matter.
My request, Lord, my request, Lord, to run the business, Lord.
ಅದೇ ಹೇಳ್ತಾ ಇರೋದು. I know that. That is why I am saying, if they still want to have them evicted only in a manner known to law, then we will direct, but the other consequences will follow. Anyway,
Lord,
I think the better thing, if they agree to allow them to participate in the auction, let them participate, and
Lord,
if they succeed, they will.
Lord, till then, Lord, at least to have a livelihood, Lord, raining season, I can't do my business, Lord, in the footpath, Lord. All are in the street, Lord.
We'll have it on 31st of July. Release this matter on 31st of July.
Till then, Lord, our goods are inside, and Lord, our material inside. We can't do, Lord, the business, Lord, in the street because of the heavy raining.
Anyway, by Monday, we'll dispose of the matter itself.
Please, Lord. Great.
Yes. Yes.
Number 38 or first, number 39.
Huh? Learned counsel for the petitioner has filed a memo dated 26/7/2023 stating that the grievance of the petitioners has been redressed since they were permitted to participate in the elections held on 27/2023, and the prayer made in the writ petition does not survive for consideration. We'll stop. Next para. The memo is taken on record subject to all just exceptions. We'll stop. Accordingly, the writ petition stands disposed of as nothing further survives for consideration in this writ petition. No.